Any mentioning?
May I have my lord's kind leave to mention, my lord, item number 27 of my lord's list, my lord. It has been fixed for witness action today, my lord. It's a 1996 suit. Before I proceed with the mentioning, my lord, I must apologize for the unusual indulgence, my lord, I will be seeking. In this suit, my lord has passed an order holding in the facts of this case, my lord. Limitation is a mixed question of fact and law, my lord. We have
26.
27, my lord. 27 of my lord's list.
Yes.
Gautam Rai suit, my lord. We have preferred an appeal from my lord's order, my lord. It is in the last limb of its argument before the division bench presided by Justice Orijit Banerjee, my lord. We have concluded our submissions, my lord. The respondents, I'm assuming, my lord, they will complete by today. We are ready to give a rejoinder by today itself, my lord.
Adjournment.
The only indulgence, my lord, if it could be kept in abeyance till the vacation.
Somewhere, my lord.
My lord, it's only in the nature of a request, my lord. I'm not standing in the way. It's
My lord, witness will be here. We are ready to adduce the evidence, my lord. Kindly seize the last portion of the order, my lord.
my lord, I hope my
And they go to the appeal court and make submissions that we are taking time in the suit and not proceeding with the suit.
my lord,
But this
may I
sort of sharp practice, my lord, should stop somewhere.
My lord, may I clarify? I'm not taking an adjournment, my lord. This is only in the nature of a request. I'm not standing in the way of my learned senior friend, and I'm certain my
There is
learned.
no bar in the proceeding.
Yes, my
There's no bar in the proceeding. It's only in the nature of a
So
request. my
come
lord.
then.
Very well, my lord. Okay.
May I have your lordship's kind leave to mention two suits, my lord, of 1999, my lord. These were transferred from the Learned City Civil Court before this honorable court, my lord. They are running in the warning list, my lord. Let them be listed. I'm appearing for the plaintiff in this matter, my lord.
June.
May I have my lord's kind leave to mention one matter? My lord, upon notice I am mentioning. My lord, this matter, my lord, is my suit, my lord, for eviction and mean profit. Well, it was due to appear yesterday, my lord, pursuant to my lord's order of 24th
That
April.
Rajasthan Patila is that.
My lord. My lord,
My lord, I'm appearing for the respondent. My lord, the honorable division bench has kept open the point regarding the forceful delivery of the possession, my lord, and has granted status.
It did
for-
come in the list. Then I'm
My
clear.
lord, kindly, if it is maybe taken up after the appeal is discussed.
my lord, the thing is, my lord, the honorable division bench also clarified that so far as the mean profit proceeding is concerned, it will, my lord, it may continue.
All right, come after vacation.
My lord,
My lord,
may I have your
Just minute.
lordship's
It will leave, come in the list after vacation.
Very well. Obliged.
My lord, may I have your lordship's leave to mention this matter? US 58 of 1987, my lord.
List today.
My lord, it was made returnable on the 14th of May, but it has not appeared, my
Check
lord.
it.
My lord,
Make it in list.
my lord, tomorrow, my lord.
They will check it.
My lord, because I'm praying for extension of time, my lord. The matter is before the learned special referee for assessment of the mean profit and damages. I'm praying for a extension. Grateful.
My lordship's kind leave, my lord, to mention upon notice, my lord, and mentioning this suit, my lord, for inclusion in the list under my lord witness action, my lord.
After vacation.
After any day after vacation.
Praying for my lord's kind leave to mention a matter for correction in the
It will appear in the list after vacation. The list will be published. It will appear in the list on that list. You check that list. Because that will possibly be the monthly list. That will appear on that.
Praying for my lord's kind leave to
Then you make a mention. I will include it and start witness action.
I'll do that.
Praying for my lord's kind leave to mention a matter for correction in order dated 13th May passed by my lord.
Tomorrow.
Grateful, my lord.
May I be permitted to mention one matter, your lordship? This matter, your lordship, was taken up on Monday, your lordship. Due to personal difficulties, the advocate for the petitioner could not be present, your lordship. We have filed an application in this suit, your lordship. The urgency is that there are several records which needs to be brought on record, your lordship.
After vacation.
Your lordship kindly keeps it under the heading to be mentioned and indicate the urgency, your lordship. If the matter can be taken up on Friday, your lordship.
Check it. Next week, I will check it. Not possible this week.
Then my lord kindly keeps it on Tuesday. Mr. Shudushatta Banerjee is appearing in this matter, your lordship. If the matter can be taken up on Tuesday.
Wednesday.
Grateful, your lordship.
My lord, may I be permitted to mention CS number 294 of 2011.
Item
It
number?
was an undefended suit. It was for pending for restoration before the Honorable Justice Krishna Rao, but the determination has been changed. So I'm praying for inclusion.
Tomorrow.
Commercial division, item number 1.
Not I appear for them.
I've heard both of you.
No, Lordship has heard him.
The powder factor Supreme
Yes, I remember.
No, I will make my
whole India.
Yes, I still remember that.
I will make my submission today.
Your submission was complete.
No, I will make it today.
Your point is that that particular clause was included in this agreement,
Absolutely.
whereas Supreme Court was hearing cases where these clauses were subsequently inserted.
Absolutely. That is why, my lord, it was taken. My lord, I tell you, Lordship.
But the one thing I said, my lord, I pointed out that in the amended written statement, they had said.
Yes, I will take up.
I will take care of you.
Identical.
Yes,
Identical
yes.
case.
I will take care of your hearing. I will take care of your hearing. Let him submit.
If it is different, they cannot be identical.
When your turn will come, I will hear you.
My lord, the present petition is for release of a bank guarantee of 94 lakhs 24,000. Lordship, kindly look at the prayer in the plaint. That is, my lord, at page 2 of the petition. The suit is also for release of that identical amount of money. Now,
that is prayer E.
Prayer A of the plaint.
Prayer E is delivery of bank guarantee.
Yes. Yes. That is the same amount of money. During the hearing of the suit, everything is ready for hearing. All parties have filed their documents, otherwise ready for hearing. At this stage, the present application has been filed, relying on an order of Supreme Court, that in view of the order of the Supreme Court, I am also entitled to get back my bank guarantee. So therefore, the direction be given to me for release of that. This is the whole prayer of the and the scope of this application. Now, my lord, the fact of this case, my lord, is relating to
But you have mentioned the issue is same and identical.
absolutely.
How do you explain this?
Issue is same and identical.
That you have stated in written statement.
Yes, that is what I'm going to explain, your lordship. But it would be absolutely clear from the order of the Supreme Court. My lord, kindly appreciate that the present scope of the suit is relating to 3 contracts between the parties. By this contract, for 3 years, the plaintiff was to supply the explosive, which was required to be used for mining operation of Coal India Limited. But a particular clause was incorporated in the contract that if it is found that the explosive is not according to the specification and it contains a powder factor, it is a technical term, a powder factor, in that case, there would be a penalty for that. This is the only provision of the contract which is now the subject matter of the present suit and the application. Well, it is not the present plaintiff alone. There are plenty of suppliers throughout the country, my lord, who had supplied these explosives from time to time, and everybody was having almost the identical clauses in their respective contract. But at one point of time, the suppliers took a point. Suppliers, not one, suppliers a lot. They took a point that the incorporation of this clause of powder factor and consequent thereto for imposing penalty is not lawful. It should not be accepted by the court, and therefore this clause should not be taken into consideration. Well, a similar type of point was taken in different high courts and also in this court. Ultimately, the matter went up to the Supreme Court. Supreme Court, although the present petitioner was not there, many petitioners were not there, some of them were there, and everybody had taken the same point that this penalty clause as contained in the contract is not lawful. That means the contract contains the clause of powder factor is also not enforceable as against the suppliers. This is not
Because
lawful.
parties were not ad idem.
Not right. That is not ad idem. They are saying that it is not lawful. Not
Yes.
not ad idem. I am not on ad
At the
idem.
time of conclusion of contract, this clause was not there.
That's right.
Subsequently, unilaterally, it was imposed.
Well, that is the two types of contract. In some contract, it was already incorporated in the contract, and in some contract, this clause was incorporated subsequently.
That is the distinction, point of distinction.
That is the point of distinction. The second limb of these matters, the petitioners, they went to the Supreme Court. But not only, they did not say that it is a de novo contract. They said the common point was that the incorporation of this clause itself is bad. At this stage, my lord, we had already completed our pleadings. So my client was advised to file a written statement, additional written statement, or rather written statement to amend that since this issue is pending before the Supreme Court, so please wait. Let us see what happened to that Supreme Court. In the meantime, the order of Supreme Court has come. But before I take your lordship to the Supreme Court order, may I take your lordship the contract itself, which is the subject matter of the present
Where is that?
suit and petition. But the contract, I understand, is not annexed here. But I have. I will
That is
show
in
you.
the plaint.
No, not plaint. I will show you from the brief of documents.
But that should be in the plaint, I think. That is in the
Plaint. Let me check. Perhaps not. Perhaps not. Achha, plaint. Plaint এর মধ্যে আছে? পেজ নাম্বার কত? না, ওটা দেখাতে হবে, পেনাল্টি ক্লজ। My lord, page 31 of the plaintiff, your lordship's kindly says, there are 3 contracts. I find that only 1 contract is there. Penalty clause. Review of your product performance will be made on the basis of fragmentation, mark piling, cost over Swanso capacity improvement achieved for total system. In the event of your product and providing satisfactory results mutually agreed upon, penalty will be imposed by your price reduction, quality reduction, withdrawal, etc. The weighted average powder factor separately for coal and OB for 10 years commencing from Swanso period shall be worked out mine-wise. The higher of the weighted average powder factor for 10 years and that of 2004-2005 shall be hereinafter referred to as the minimum yield. Mine-wise achievement powder factor should not be less than the minimum yield referred to above. For every 1% of part thereof, decrease in powder factor of coal compared to
the powder factor.
This is the powder factor. So it is incorporated in one of the contract itself. It's not the subsequent incorporation in the contract as Supreme Court has held in different matter. Similarly, there are 2 other contracts. May I show that 2 other contracts from the judge's brief of document? I don't know whether judge's brief of document is there before your lordship.
Possibly not.
Possibly not. May I show your lordship from my copy? From my copy.
Page 41.
Page
41.
Of the plaint?
Yes. Have you got it?
Yes.
The weighted average second paragraph.
Mine-wise, yes. Mine-wise achievement of powder factor should not be less than
They have a
The meaning-
paragraph also.
minimum yield. So same paragraph, my lord, same type of clauses is incorporated. So my lord, similar type of clauses are there in the all the three contracts, and all the three contracts are the my lord, the part of the suit record before your lordship. Now, my lord, this position was, my lord, it starts from page 40. I think page 40, powder factor, clause 22. Supply against this contract shall achieve the mine-wise minimum weight average powder factor separately for coal and OB as indicated as Annexure B. Failure to achieve the benchmarks listed in Annexure B shall attract penalty as detailed in performance and penalty clause CDR 23. And 23, my lord, is the performance of penalty. My lord, I have got all the three contracts in the judge's brief of document. It is a part of the record, and each of the contract contains the same provision, same clauses. So therefore, first of all, this contract is a part of the contract which has already been concluded between the parties, which contains all these three clauses. My lord, on this basis, the matter went to the Supreme Court in respect of different matter. Now, Lord, when the matter went to the Supreme Court, my lord, I advised my client to file an additional written statement because at that stage the suit was going to take up by the court for regular hearing. At that stage, it required, my lord, a written statement to be amended. My lord, kindly see what I have said in the written statement. Kindly see the addition my written statement, amended written statement.
না ধরো এইটা থাক এর মধ্যে দেখেছি
My lord, kindly take my additional written statement. Page 10. Page 10. Paragraph bolo. Paragraph 13.
অ্যাডিশনাল রিটেন স্টেটমেন্টটা দাও
কোথায় রে?
রাখো
এটা? My lord, kindly take my additional written statement.
There was a written statement,
Yes.
page 38 of the petition.
My lord, the amended written statement. The amended written statement which was relied on. Para 13A, 13B. May I place, my lord, 13A and 13B?
Yes, this is amended written statement.
Yes. Three contracts were separately entered into with the plaintiff for two different periods for the supply of explosive and accessories. Insofar as the supplies under the contract of 2006 and 7 is concerned, there was no dispute as such. There was no claim of either of the party against each other. The said contract came to an end, and subsequently, the bank guarantee which was furnished against the security deposit on the said contract were released in favor of the plaintiff. But insofar as the contract of 2005-2006 is concerned, which is the subject matter of the present suit, dispute raised with regard to the determination of the penalty by reason of not achieving the powder factor by the plaintiff in respect of the supplies made by them. There was various other suppliers. Here is the point. There are various other suppliers like the plaintiff in different parts of the country who had also supplied the explosive and accessories during the period 2005 and 2006. And similar question had arisen with regard to the determination of penalty by the defendant. The right of the defendant to deduct from the bill of supplies on account of powder factor was challenged. Well, here is the point. The question was raised as to whether the Coal India has got any right to deduct the money on account of this powder factor was the subject matter of dispute raised by different suppliers in different writ petitions and, my lord, in the suit. My lord, kindly says, the right of the defendant to deduct from the bill of supplies on account of powder factor was challenged, and matter had ultimately gone to Honorable Supreme Court of India. The said issue is now pending for adjudication by the Supreme Court. Although the present plaintiff is not a party to the pending matter before the Supreme Court of India, but since the issue is same and identical, the defendant could not calculate the penalty of such a. So, my lord, we were under impression that the Supreme Court will decide the issue with regard to my right to impose that penalty clause in the contract, whether I have got right to deduct any amount of money by reason of powder factor stated there. So that was the issue, was under our impression the court will look into. But ultimately the Supreme Court has not gone into that aspect. Supreme Court has gone on a different aspect altogether. May I show your lordship from the order of the Supreme Court?
Page 87, I think.
Page, I think, yes, page 87. The applicants in the three appeals who had approached the High Court under Article 226 of the Constitution have been non-suited on the ground that the contract entered into by them, my lord, kindly mark it, that the contract entered into by them with the Coal India Limited for supply of explosives was in the realm of a private contract involving no public law element, and hence not amenable to scrutiny in the exercise of jurisdiction under Article 226 of the Constitution. We have perused the order of the High Court under challenge and have heard the learned counsel. The grievance raised by the appellants as writ petitioners, which have been refused an adjudication on merit, is that a supplementary clause in the contract agreement was which has the effective novation of the contract. Is it the case of the petitioner here that a supplementary contract was entered into? Madam, kindly may I place this paragraph 3 again? The grievance raised by the appellants as writ petitioners, which have been refused an adjudication on merits, is that a supplementary clause in the contract which has the effect of novation of the contract has been unilaterally inserted therein by the respondent Coal India Limited. It was urged that the said supplementary clause clearly nullifies the clear understanding and terms of the original contract contained in so and so. The original contract supplementary clause are inserted. Then so and so. Then ultimately, my lord, kindly come to the ordering portion of the Supreme Court. Page 92. It's not 92, my lord. Kindly come to 94. Page 94. Paragraph 7. Having perused clause 15, well, clause 15 has been quoted in the order. Clause 15 is, my lord, at page 91. At page 90.
That I told you, not ad idem, beyond the intent of the parties. That was, I can remember, that was observed by the Supreme Court.
That's right. My lord, so 91, this Supreme Court matter is relating to, my lord, a supplementary clause, which was not originally in the contract. And because of that...
That was the observation, parties were not ad idem.
Not ad idem. That's right. So this is the elementary principle of law. What the parties have not contracted, my lord, so parties cannot be made liable for anything which is not covered by the contract.
Where the parties are not ad idem.
Not right. That means the parties are not idem. That means that is either concluded contract or not a concluded contract within the meaning of the Contract Act.
If something new is there, then that's a tantamount to novation of contract.
Absolutely. Now, my lord, is it the case?
In that context, this case was
case, and that is why Supreme Court has ultimately held. Page 95. It is therefore our considered view that the supplementary clause constitutes a novation of the contract which could not have been done unilaterally, and such unilateral action on the part of the Coal India Limited violates Article 14 of the Constitution of India and therefore liable to correction in exercise of writ jurisdiction. No question of appreciation or evidence can thus, etc. Now kindly come to page 96. We therefore set aside the order of High Court and direct that all consequential benefits following from the present order will now be conferred on the appellants without any delay. We, however, made it clear that in the event the consequential benefits under the present results, a refund, such refund will be made forthwith, but without payment of interest. But that is the distinction between the matter before the Supreme Court and before your Lordship. I have placed the entire contract before Lordship. Now I have placed the plaintiff before your Lordship. Is it the case of the plaintiff that this is a case of novation? Plaintiff does not just say anything about that. They have not shown any particular clause, which is a supplementary clause, as that clause was there before the Supreme Court, and Supreme Court has itself, my lord, quoted that supplementary clause at clause 15. I have shown your Lordship from the order itself. And now what is their case? In view of the order passed by the Supreme Court, now I have become entitled to get refund of the bank guarantee money. And that is at what stage? When the suit is otherwise ready for hearing. But whether suit is ready for hearing, whether suit is not ready for hearing, question is not on that. Question is on the principle. Question is on the applicability of the Supreme Court order in this case before your Lordship. And that is the whole moot question before your Lordship in this matter. That is the grounds for the present application. My lord, kindly see the present application. What are the grounds? Petition. Petition.
Para 15, page 10.
The Honorable Supreme Court has since then heard the matter along with civil appeal number so by a judgment or order, finally disposed the same by holding that the insertion of the supplementary clause in the contract constitutes novation of the contract, and such a unilateral action of so is liable to exercise the jurisdiction. So it is his own case, my lord. The Supreme Court's case is a case of novation. Here the plaintiff case is not the case of novation. Plaintiff before your Lordship kindly sees whether the plaintiff has made out any case as to whether this contract which has been entered into between the parties is a novation. Whether the powder factor clause as contained in those clauses which I have shown are the novation. Novation means, as your Lordship knows, that which has taken place beyond the contract.
New.
And the new, and of which the parties are not ad idem. This is not that a contract. Contract is explicitly clear.
All right. How do you? Yes, Mr. Mitro.
May your Lordship knows, my lord, a decree can be passed, order can be passed on the basis of admission made by the defendant in the written statement.
Which admission?
Kindly have a look at his application, his affidavit in opposition to my application. That application, affidavit in opposition starts from page 16.
Ew.
My application
Yes.
was verified. Kindly see, my lord, verification is at page 14, 20th December 2017.
Which paragraph you are referring to?
My lord, kindly see page 14 of my application.
Of your application?
Yes.
Page 14 is the affidavit.
Yes, no, I'm just showing the date, 20th December 2017.
Hmm.
Now come to Annexure B. This is the amendment.
Page
It starts at page 18.
80.
18, 18. Can you look at page 17 first? What is the phrase? Leave be granted to the petitioner to amend the written statement filed in so and so. Not in that. Is asked for leave. Then direction begin to incorporate such amendment in the written statement. Then leave be granted.
That is prior to filing of your application. Prior to filing of your application,
Amendment to the written statement. So he wants this. Then he affirmed this on 15th of September 2016. This is prior to my application. Then kindly see, my lord.
you show me where is the admission.
Now kindly look at page 23. 22 first. 22. Internal page 3 of his affidavit. Para 2. The defendant has filed a written statement in the above suit on May 5, 2009.
That is in the AO.
AO. Para 2. Page 22. This is the application.
Para 2 of affidavit in opposition.
Yes.
No, there is no para.
This is the application to amend the written statement. He has annexed that to his application for.
Which one you are referring to?
Can you look at para 23?
23 of what?
Page 23 of the application, Annexure B.
Well, the application for amendment of plan has been culminated in the order.
All right, please let him submit.
May I please, Your Worship has got para 2?
Such a issue is not only subject matter of the contract.
Can you look at page 22 first? Of my, the defendant has filed a written statement in the course of hearing, para 3. At page 22, Your Worship has got it. In the course of hearing of interlocutory application. Lordship has got that one. Filed by the plaintiff. It was ascertained, that was my first interlocutory application, that the certain further fact, I don't understand this. It should be the certain further facts, that these certain further fact also required to be incorporated in the written statement in order to clarify the fact which has already been disclosed in the written statement. As a matter of fact, at the time of filing a written statement, the said fact could not be disclosed inadvertently or by mistake. Such omission has been categorically mentioned in the affidavit in opposition filed in the interlocutory application which has been disposed of. Your petitioner therefore states that the present application is being filed for elucidation and clarification of facts which have already been disclosed in the written statement. Elucidation and clarification of facts. So no new facts, because then it will be difficult. He's saying for elucidation and clarification. Now what is he elucidating and clarifying? Can you see para 4? The fact which have inadvertently not disclosed in the written statement are with regard to two separate agreements between the parties for supply of explosives and accessories for a period 2005-6 and 6-7. Insofar the contract 6-7 has already come to an end and there was no dispute whatsoever nature with regard thereto. The only controversy which remained unsettled was relating to the contract of 2005 and 6, i.e. with regard to determination of the value of the penalty on account of powder factor. With regard to determination of the value of penalty on account of powder factor against the supply made by the plaintiff. This is very important. He has amended it to elucidate. Such controversy is still pending before the Honorable Supreme Court. So this controversy which is there is pending before the Supreme Court. He did not mention it earlier. So now he wants to bring it on record. Very well. And unless and until the said issue is being adjudicated, it is difficult to assess the penalty on account of failure to achieve the powder factor in terms of the agreement. Where does he say that this case is not similar? He knows he's a party in the Supreme Court. Why is he saying that he should say the Supreme Court? There's no such thing. He should not have amended the plain at all, written statement. If the Supreme Court judgment was not relating to this case, he ought not to have amended the written statement. Where was the need to amend the written statement? only to bring into account the Supreme Court and say it's factually identical. Therefore, I cannot proceed in your matter unless the Supreme Court gives judgment. If the Supreme Court, he was before the Supreme Court, I was not before
And
Supreme
your submission is, since he has stated that both issues are identical, and at that time the Supreme matter is pending before the Supreme Court delivered judgment. Now that judgment they have to rely upon, because they have said the identical issues.
And kindly see, my lord, he has gone on further. Unless such controversy is pending, it is difficult to assess penalty on account of failure. Why? Why is it difficult to assess penalty? You assess penalty on basis of contract. Why are you relying on Supreme Court? Because as he says, there is no novation here. Those cases are all concerned with novation. And he is a party in all those cases. Where was the need? If the Supreme Court judgment is not relevant here, where was the need to amend the plaint and bring on record the Supreme Court?
Right. Hard, both of you, I will pass order.
Yes, ma'am. And I have shown in the affidavit reply that the last document, the release.
Yes, I have seen that. Marked it.
Coal India itself has said. So if it was relevant, they wouldn't have said.
Next matter.
I'm grateful to your lordship. Those are my submissions. He has brought the Supreme Court on record. I have not brought. He has brought. And said it's identical, so therefore I cannot proceed. Now Supreme Court has given, now he's blowing hot and cold. He's saying, no, it's different. Cannot say that. He was before the Supreme Court. Why did he bring the Supreme Court?
Matter is over. Already.
All right. I have heard it. Next matter.
Cannot approbate and reprobate. Lordship is giving it for judgment.
Order.
For
Why
order.
judgment? This is an interlocutory application.
Whatever way.
I will try to give it today. If not possible, I will reserve.
Any day, my lord. I am not on standing in the way. This is an old matter. For 1 or 2 days.
I will try to dispose it of today. If I do not get time, then I will reserve it. After a couple of days, I will pass it.
Yes, it's kindly do. Whatever it's agreeable to your lordship.
It should not be kept pending, at least, I can assure you.
Because the Supreme Court is there, my lord. That is why I made the application.
It will not be kept pending.
It will not be. No. Your lordship never keeps things pending. I know that. Short judgments.
Milord, 2 and 3, Milord, I am for the plaintiff. The
Not for? Sesa.
Yes, Milord. And Milord, there are 2 applications by my learned friend, Milord, under Section 8 of the Arbitration and Conciliation Act.
4 is Section 8 application.
Both are Section 8, my lord. In the
Section
two
8?
suits, my lord, there is
Oh,
two similar
two
Section 8
two
applications.
suits.
Yes, my lord.
Yes.
Two suits from the same contract, my lord, similar.
What is the
section.
basis of Section 8 application?
Section 8, my lord, there is an agreement, my lord, which has an arbitration clause. That arbitration clause has been invoked, my lord, for the last 10 years, and arbitration has been ongoing, my lord. This is the basis. This entire claim,
And
my
now
lord, in
they
the
have
suit
come
is
out
covered
with
by
this
the.
And Milord, the bank is not a party to the arbitration, Milord. In any case.
Milord, my claim is that in the suit number 157, we have not been served with the copy of the petition filed by.
My lord, given it to the client, my lord, perhaps.
But it has not reached.
My lord, one request, my lord, Mr. Rotang, I'm being led by Mr. Rotanko Banerjee, my lord. Last day also, he has argued for at least, my lord, 15 to 20 minutes, my lord. He was waiting, my lord, some matter got called up, my lord. I'm praying if after vacation, my lord. Because he had started already, my lord. That's why.
After vacation?
After vacation, because now there is no time before vacation. My lord.
On prayer of the learned counsel for the defendant.
Defendant number 1.
Have you filed WS in this suit?
WS, no, my lord. This is our first statement, my lord, Section 8.
The matter is adjourned to, both the matters are adjourned to 28th June.
Let the direction be given to serve.
Yes,
the
Milord,
Well, we'll give them a copy. Copy the
Let them-
We'll give a copy.
4.
Last submission I have submitted suggested.
I'm carrying it.
Supposed to
Give it.
file the.
I'm carrying.
You suggested issues, suggested issues আছে? You are plaintiff.
Last submission I have.
You are plaintiff.
Yes, I'm for the plaintiff.
চেক করে নাও, আমাকে দিয়ে দেবে চেম্বারে। চেম্বারে দিয়ে দেবে।
On 10th of May, I have filed, Milord, that has been recorded in your lordship's order. On 10th of May, I have filed,
All right.
and that has been recorded in your lordship's order also.
But I have filed it only on behalf of defendant number 1.
All right, I will check it. I will frame issues.
I'm only appearing for defendant number 1. So,
All right.
grateful.
Witness is there?
Because, no, my lord, I don't see the witness. My learned friend is there.
Possibly not got visa.
I am appearing on
But
behalf of the
it's been quite a
defendant.
long time since the matter is getting adjourned. They ought to have applied
Your
19th.
Lordship, I am appearing on behalf of the defendant LC issuing bank. Your
What
Lordship.
happened to you?
Your Lordship, I am not well. Hence, kindly grant leave to appear virtually.
What happened to your witness?
Your Lordship, the plaintiff had filed an application for disclosing and relying on further evidence, which is why they also want to recall the plaintiff's witness. And Your Lordship, what has been stated in the application is that after the defendant's witness is over, they will bring forward with the plaintiff's witness. Your Lordship, we are objecting to that. Hence, we
Whatever you
also
are
have.
objecting to or
Yes,
not, today the witness is fit for cross-examination of the witness possibly.
Your Lordship,
Yes, my lord, the
on the last
cross-examination is
occasion
going on.
already, on the
Let the
last occasion
cross-examination
only,
be over.
my learned senior, my leader, Mr. Rupak
Dr.
Ghosh had
I'm here.
indicated, Your Lordship,
Mr.
that
Doctor.
after. Oh, I apologize.
My lord, it was decided that this application will be decided first and then the cross-examination will go ahead. My lord, the affidavit is ready. Kindly allow us one committee report. My lord, that has to be sent to Bangladesh and my lord affirmed. The affidavit is ready. Kindly give us some time. We'll file the affidavit. Lordship hears out the application, then my witness will be here. I am for the defendant number 4, the bank.
Your Lordship will kindly see the conduct. My lord, 19th of April, your Lordship was pleased to give them direct
Documents,
May I?
volume, we had to also go through
Mr.
it.
Ghosh, the learned
Mr.
counsel
Ghosh, may I
appearing
have
for
the-
defendant number 3.
4.
4. The matter is adjourned to 28 June. No further adjournment shall be allowed.
My lord.
Adjournment given is
My lord,
permitted.
2005 suit for this application, my lord, the affidavit.
Next time I will close it.
Yes,
Next time I will close it.
but my witness was in the box. Your lordship knows now they have made an application.
New case has been made out, so naturally we have
I
to
will
demolish
decide
that.
it. I will decide it.
And that is the plea for not getting the suit heard.
Item number 6.
Grateful, Your Lordship.
My suit, on the last occasion, I had indicated to your lordship that my witness was suffering from an eye problem, and because of which he had undergone surgery also. And pursuant to your lordship's leave granted, we had disclosed further documents, and they have taken inspection.
Today is for witness action. Have you brought your witness?
No, my lord, the same problem which I had indicated on the earlier
Eye
occasion
problem.
also. Eye problem continues. He is giving injections on a daily basis. We have disclosed further documents. The admission denial is yet to be filed by my learned friend.
Additional documents. My lord will kindly give us a little time to complete the admission
All right.
denial of the additional documents.
Learned counsel for? You are for?
I'm for the plaintiff.
Plaintiff submitted that the witness, because of eye problem, because of ailment, is not able to appear before this court for giving testimony. Semicolon. Accordingly, she prays for accommodation. Adjourn to full stop. Next para, adjourn to 27 June.
My lord, only
New
one.
document is disclosed by the learned counsel for the plaintiff. Inspection is over.
Yes,
Inspection is
we have
over.
given
I'll only
inspection.
give my admission and denial, my lord.
The learned counsel for the defendant.
Defendants number 1 and 2.
Defendant number 1 and 2 submitted that inspection of the newly disclosed documents are over.
Yes,
Semicolon.
Inspection.
Inspection
is over.
Inspection is over.
The admission
Affidavit of
denial is
admission
outstanding.
and denial of document is to be filed, and also prays for accommodation. Let the matter appear on the returnable date.
My lord, may I be permitted to file the judge's brief, the additional disclosure?
Let that be done. Come on the next date.
My lord, one humble submission.
Liberty is given the parties to mention.
Notun document nahi. My lord, one humble submission. I am instructed. Inspection is not over. If it is not over, my lord allows us to
ঠিক আছে
complete
ওটাকে লাইনটা কেটে দাও ওই লাইনটাকে কেটে দাও নেক্সট প্যারা নেক্সট ম্যাটার
it. If it is not over, আমি over বলছি না। যদি
Item
পুরো
number
টাকা
7.
শেষ করে দিন।
Grateful.
Item number 7. Lordship, I am for the plaintiff. My lordship, its matter has been transferred to the commercial division.
Take your breath. 8.
Now, your lordship, we have already prepared your lordship with the statement of truth and the other compliances. It could not
Accommodation.
be- One date, your lordship, our affidavit of...
On prayer of the learned counsel for the plaintiff.
Yes, your lordship.
Plaintiff time is extended to file statement of truth and other affidavits. The matter will appear in the list on 22nd May.
So may I file, your lordship? It's ready. May I file it before the honorable court, your lordship, if your lordship desires? And then other.
I fix it 22nd May, come on that date.
Lordship.
My lord, I'm for the defendant.
You have to take steps also.
Yes.
Let this be filed.
My lord, I'm praying for some more time because I'm told
I have
that
not given you any time as yet. Let that be filed.
And your lordship, we have requested them to serve a copy of the admission denial so that your lordship, we can prepare our affidavit on evidence, and
that we shall do.
I'm grateful, your lordship.
Item number 8.
না 7 হয়ে গেল 8
Your Lordship, I appear on behalf of the plaintiff.
I appear for the defense.
witness action.
Yes, my lord. I also start the cross-examination.
Where is witness?
Your Lordship, the witnesses. Your Lordship, I'm
For
filing.
bank guarantee.
Your Lordship, I'm filing my statement of truth along with the list of documents and affidavit.
Statement of truth along with list of documents and affidavits are filed on behalf of the plaintiff. Let the same be kept in record. You have to file that. You have to file that.
I'm sorry, my lord.
You have to file.
My lord, my statement of truth is ready, my lord. It could not be affirmed.
Serving upon the affidavit and the order 11.
The defendant shall file statement of truth and affidavits on the returnable date. I am giving you accommodation on the
You can
returnable date.
Start the cross-examination.
Cross-examination be started
Yes, my lord.
to expedite the matter.
Yes.
He is already on oath, I think.
Yes, my lord. Chief is over. Pardon?
Your name, sir?
Anand Agarwal. Mr. Agarwal, when was the plaintiff company incorporated?
Sometime in 98, I'm not very sure.
Will you be able to tell the precise date on the next date?
Yeah, sure. Definitely.
Mr. Agarwal, who were the initial directors of the plaintiff company?
Mr. Kailash Agarwal, Mrs. Rama Agarwal, and I think Mr. Mahesh Agarwal. I'm also not very sure about that. Mrs. Rama Agarwal and Mr. Mahesh Agarwal. I think.
On the next occasion, will you be able to
Yes,
tell
I will be able to.
the
Yes, yes.
correct exact names?
Exact names, yes. Names.
Names. Mr. Agarwal, who were the directors of the plaintiff company in the year 2010?
Myself and Mr. Kailash Agarwal. I think both of us were the directors.
Would the answer be the same if I ask you for the year 2015?
Yes.
Were there or are there any other directors in the company, plaintiff company?
No.
Would you be in a position to tell, tell my lord, that when did the other persons, namely Mahesh Agarwal and Rama Agarwal, resign from the directorship of the plaintiff company?
I am not sure about the year or dates. I'm not sure about the year and date. I will have to check.
Mr. Agarwal, how many bank accounts did the plaintiff company have?
Is it for a particular period you're asking or not?
Initially.
Initially, it was State Bank of Bikaner and Jaipur only, and Standard Chartered Bank.
State Bank of
Bikaner and Jaipur,
Open a bank account in
Standard Chartered Bank.
Was it a current account that maintained with the state bank, with the defendant bank?
No, it was an overdraft facility. Cash credit. It was a cash credit facility. There was a cash credit facility.
Are you still enjoying the cash credit facility with the defendant bank?
No.
When was this cash credit facility closed, Mr. Agarwal?
I think probably 2009. I'm not very sure. If you want, I can cross-check that. Very sure. If required, I can cross-check that.
And was this cash credit facility availed by the plaintiff company since its inception?
No, later on. It was initially a partnership firm. Then it was made into a private limited company. Converted into a private limited company. After a few years, I think we availed the facility.
Did the plaintiff company continue to use the banking facility with the defendant bank after the closure of cash credit facility?
Yes, the account was operating. The account was operating.
Is it still in operation?
No, now it is closed.
When was it closed, Mr. Agarwal?
I think the bank initially, when it was Standard State Bank of Bikaner and Jaipur, then SBI took it over. It was State Bank of Bikaner and Jaipur. Then State Bank of India took it over. Sorry. And Jaipur. Then SBI took it over. And I think we closed it in sometime 2000 and no, we closed recently 2018 or 19. I'm not very sure. If you want, I can cross check that also.
On the next occasion, can you tell the exact date of
Definitely.
closure of the
account
with the defendant bank?
Yes.
Mr. Agarwal, who is this Mahesh Agarwal and how is he related to you?
Mahesh Agarwal is my uncle.
Is he a paternal uncle or a maternal uncle?
Maternal uncle. Paternal uncle, sorry.
And who is this Mahavir Prasad Agarwal?
My paternal uncle. Mahavir. My paternal uncle.
What about Mr. Kishori Lal Agarwal?
He is my grandfather.
Is he still alive?
No.
And what about Mr. Pawan Kumar Agarwal?
He is my paternal uncle.
And Mr. Anand Agarwal?
I am Anand Agarwal.
Sorry, I'm so sorry.
No,
Was your father at any point of time a director of BSG Foods Private Limited?
Yes, he was a director.
And when did your father resign from the directorship of BSG?
I will have to check
Food
that.
Private Limited?
We were not in direct control of the company. It was in control of my uncles. Control of the company. It was in control of my uncles. So if you want, I can cross-check with them.
Mr. Agarwal, who were the directors of the plaintiff company as on 31st of March 2022?
The ROC filing is still due. My father is deceased in 22. Due. My father has been deceased in 2022, March. So the filing is still due. So as of now, as per records, it will be Mr. Kailash Agarwal. On the record, it will be shown as Mr. Kailash Agarwal and Anand Agarwal.
You speak a little bit slowly.
Sorry. Yes. 2. Yes. So ROC filing is still due.
But your father is no more. You had deposed it on the last.
Yes, he is no more. I just said that.
Mr. Agarwal, under the law, can a company operate with a single director?
No, it cannot operate. But we are not doing any transactions in the company. Not doing any transactions in the company.
Go ahead. These are points of argument, not point of smiling.
Mr. Agarwal, please come to Exhibit M, demonstrator. M. Exhibit M. M. Exhibit M. M. Shown Exhibit M series.
M series.
Mr. Agarwal, kindly come to Exhibit M1 and tell my lord, where would I find the schedule mentioned on the first page of Exhibit M1?
The schedules are all mentioned as serial numbers 1, 2, 3, 4. All schedules are mentioned as 1, 2, 3, 4, 5, 6, 7, 8, and 12.
Have you produced these schedules before this in the instant proceedings?
It is not there with it. It is not attached to this.
Would your answer be the same for Exhibit M2?
Yeah, the schedule numbers are mentioned. But the schedules are not attached, which we can give if required by the court.
Very good. Mr. Agarwal, since the plaintiff company was enjoying a cash credit facility, how frequently was the plaintiff company submitting its balance sheet with the defendant bank?
As and when asked for.
If I suggest to you that you were required to submit quarterly, would I be incorrect?
Quarterly would be incorrect.
Half yearly?
Still incorrect. I think it is a procedure which was, I think, now it is yearly. What it was, sorry. I think the present procedure is to submit annually once the audit is done. Once the audit is completed, I think that time also the procedure would have been the same. I'm not very sure about it.
Mr. Agarwal. Will you be in a position to disclose the original minute book wherefrom the extracts have been reproduced and marked as Exhibit O?
I will have to check the records in my office. Records in my office.
Lord, may I continue on the next day because he has to bring on certain documents.
All right. PW1 is cross-examined in part. Further cross-examination is deferred to 17 June.
17.
No, not 17 June.
17 June may be a holiday.
Yeah. आगे करो. 13 June. 13 June.
I'll not be there now. So either we push this or after
Come.
Your Lordship,
Come here and
my client will not be in town on the 13th.
When will be there?
come here. Come here.
After 20th June, Your Lordship.
24th.
20.
Grateful, Your Lordship.
24th June.
No, in the meantime, Lord, we will file our statement of
truth. That is already ordered. Dictation দিয়ে দিয়েছে ওদের সেটা.
Regular list. Item number 1.
The GA5 is my application. I am for the defendant's minute. So,
Which was the plaintiff?
With the plaintiff, this was a suit which was dismissed ex parte, dismissed for default on 19th December 2022. Thereafter, nothing has been done to bring this to restore the suit. Also, the plaintiff company, which was there, has since been struck off. And they have also filed an affidavit in another proceeding before this honorable court, saying that the plaintiff is not in existence. And with regards to the plaintiff and the defendant number 1, there has been an agreement which has taken place, and thereafter these civil suits are of no relevance. So that in that perspective,
what is your prayer?
Today I am with a very innocuous applications whereby I am saying that I had deposited
original bank guarantee.
Yes, that has to be now released.
Where have you stated that this plaintiff is not in existence?
Yes, we kindly have a look, at paragraph 9, of my application. Also, I've made annexures also. I'll take my through the annexures to demonstrate.
I indicate only two things before your Lordship.
Your plaintiff.
I appear for the unfortunate board of directors of the plaintiff whose company has now been struck off. Your Lordship knows under the provisions of the Companies Act, I get 20 years to revive the company or restore the name of the company. Admittedly, the suit has been dismissed for default on 19th of December 2022. So, my learned friends, application either has to first has to restore the suit, otherwise there is no proceeding on board. And second thing is that there is no proceeding on board without the suit being restored. Your Lordship knows that's the fundamental thing, but I will not
This is
comment on
the
that.
consequential order. After
Absolutely,
dismissal, consequential order.
So, Milord,
consequential.
so Milord, initially, Milord, kindly, Milord, gives me some time. I'll come back, Milord, with
When
proper
your
instructions,
name is
Milord.
struck off, how can you make an application?
Milord, I have not made any application.
Not time. You have enough time is given.
Milord, I'll tell your lordship, Milord, that there is difficulty over here. Milord, my learned friend is pressing for an application. I do not know. I do not have a copy of the application. I am the unfortunate board of directors who have, Milord, missed, Milord.
Where have you stated that?
What, Milord?
Where have you stated that?
The fact that this company is not in existence.
Yes.
Paragraph 9.
But that is not an admitted fact. That I have, Milord, the master data, Milord, with me, which is, Milord,
Connects
struck
the
off.
master data also and the affidavit of my learned friend's clients in another proceeding before this honorable court, where they say that the company is not in existence.
Where is Annexure D?
Annexure D.
Which page?
Yes, Milord, I'll take Milord to the annexure. Annexure D, Milord, is at page 33, Milord. But I'll take Milord to relevant portions of it's a longish affidavit. Milord will first come to Milord, page 73. Running page 40 of the affidavit, Milord.
Page 73.
Yes, Milord. Running page 40 of the affidavit of annexure D, Milord.
Yes.
Where my name is appearing as defendant number 93, Milord. We'll see Sartaj Hotels. Yes, Milord, I am that. Now, Milord will kindly take with me the various paragraphs on and from paragraph 9 at page 58. Running page 58 of the affidavit, Milord. Page 50 in the partition suit.
In the partition suit.
Page, which page you are referring to?
I am referring to running page 58 of the affidavit. Now, this affidavit, which they had filed with respect to a partition suit between the brothers.
58 of this application.
Of the affidavit, that will be page 91 of the application. Page 91 is the running page 58 of the affidavit, which I am relying upon. The paragraph 9 has my lord got it?
Paragraph 9 is not in, yes.
Yes, Lord. With reference to paragraphs 11 and 12 of the said application, I say that the Union General Company Limited, as referred to in the said paragraphs, was at the relevant point of time being managed and controlled by the joint family properties, and its affairs were looked after by the respondent number 1. Like most of the other matters, the respondent number 1 was in charge of the said Union General, and the funds in the Union
No longer
General
in existence. You have stated that.
Not in existence. Also, we will now take paragraph 10. But I will read from forever. In the middle of the paragraph, however, the plaintiff states that irrespective of the said proceeding, the fact remains that the agreement of 96 and the rights thereunder are joint family properties. So far as the plaintiff has been able to ascertain, the person in control has mutually negotiated with the respondent number 1. And Milord, thereafter, Milord will kindly see paragraph 93. Up to Milord, page 94 and page 95, Milord, the last five lines. The fact that the settlement has been arrived at with the applicant company is evident from the conduct of the applicant company itself. And Milord, before that, Milord will kindly take paragraph 13 at page 94. I say that in view of the settlement arrived at with the applicant suits of 99 and 2000 have become irrelevant.
With paragraph 20 of the said application, I said, page 94.
The page 94, paragraph 13. Yes, Milord, with reference to paragraph 20.
I say that in view of settlement
arrived at with the applicant suits of 99 and 2000 have become irrelevant. So, Milord, there was a settlement arrived, the parties have been paid, and that is, therefore, Milord, in the partition suit which the board of directors had constituted and have, in that also, Milord, there was no claim with regards to me. The company has also been struck off. Therefore, Milord, the party...
How can you say the company name is struck off?
Yes, Milord. I have annexed at page... we will see page 106 of the application. I have annexed the master data. From where it will be... We will see page 106. The company status towards the bottom of the page, strike off. In 2007, Milord, was the last AGM held. Thereafter, the company has been struck off. Milord, thereafter, the affidavit which I was showing, Milord, starting from page 33, Milord, is an affidavit filed as late as in 2016 in a proceedings before this honorable court.
Where is the copy of that bank guarantee?
Yes, my lord. Now, the bank guarantee copy, my lord, that has been extended from time to time. My lord, the present bank guarantee, my lord, details are mentioned at page 108, my lord. But after the suit being dismissed, my lord, I had written to the registrar seeking for, my lord, the bank guarantee being returned. But the details of the bank guarantee are mentioned there, my lord. At page 108, my lord. No, the registrar replied saying that there has to be a pertinent or
this bank guarantee was given pursuant to order of this court.
Yes, my lord, order of this court.
Why this is in the pleading?
The order, my lord, is at page 14. It starts from page 17, and with the relevant portion of the order is at page 26. Now, may I place the portion? At page 26, the last paragraph. For the aforesaid reasons, therefore, we dispose of the appeal finally by treating the same on days list along with the application for stay. We set aside the order under appeal and direct that any injunction with respect to the property in question issued by this court shall stand vacated and withdrawn immediately and forthwith. We also direct the appellant to file and furnish a bank guarantee in the sum of rupees 51 lakh to the assistance of the registrar within a period of 6 weeks from today. Until then, therefore, the interim injunction restraining the appellant from dealing with the property in question shall remain in force. It shall stand vacated on the day the appellant furnished the aforesaid bank guarantee. Nothing. That is the reason why we had furnished the bank guarantee. The suit settlement had been arrived at in 2016. In their affidavit, they say yes, a settlement has been arrived at, and the suits of 99 and 2000 have become irrelevant. The company got struck off in 2007. And now the Billet's order that had been pleased to dismiss the suit for non-prosecution. And I am therefore entitled to this consequential relief for release of the bank guarantee which I had furnished before this honorable court. Before this date, this matter has been running on not less than 5 occasions in my lord's list.
Yes.
Lord, may I, my lord, give one suggestion, my lord, subject to your lordship's, my lord, kind consideration. Lord, if your lordship, my lord, kindly takes, my lord.
I ask a question before my learned friend even makes a submission. That I ask a question to myself. Does he have any locus today, without making any application and not being?
Is there any bar in hearing him?
No, definitely not. I'm sorry, my lord.
Is there any reason why you should intervene suddenly?
I'm sorry. I'm sorry.
My lord, from my lord, the submissions, I do not have a copy of the application. From these submissions, my lord, made, my lord, by my learned friend, my lord, 3 things emerge, my lord. My lord, there's a partition suit between, my lord, the brothers. The partition suit, my lord, also, my lord, the subject matter of the partition suit also entails, my lord, the companies which are involved over here. Hence, my lord, the affidavit talks about, my lord, those, my lord, companies. Now, my lord, several disputes are there, my lord, with regard to, my lord, the partition suit which is pending. I do not know, my lord, which affidavit my learned friend is, my lord, relying on. I need to have a copy of the application. If your lordship so kindly, my lord, considers. My lord, may I?
You are representing whom?
My lord, I am representing the board of directors of one of the company which have been struck off the plaintiff company. Now, my lord, if your lordship, my lord, so, my lord, feels it, my lord, fit and
Not
kindly
necessary.
considers.
It is pending. It was dismissed in 2022. After 2 years, you are coming. I will pass order.
My lord, I'll tell you, lordship, one more difficulty in this. My lord, today, the suit is, my lord, dismissed for default, and the suit is not on board before your lordship. Until and unless, my lord, the suit is restored.
Who will restore?
My lord, it is duty upon me to, my lord, restore. Really, my lord, the duty upon me.
When it
The
was
company
dismissed?
was, my lord,
When it
struck
was
off
dismissed?
2019, 2022, 19 December 2022.
Today is?
I completely bowed down, my lord. I could not have because, my lord,
I
my
will pass
company
necessary
was,
order.
my
No further
company
hearing.
was struck off, my lord, on
Next matter.
Obliged, my lord.
Item number 2.
My lord, I am the special officer, my lord. By my instance, this to be mentioned matter has come. Day before yesterday, I mentioned this matter and lordship has accommodated.
What?
Accommodate this to be mentioned matter.
Yes.
The plaintiff, the defendants are here, my lord. Certain things have come, my lord. This matter was last heard on 30th of January by Justice Rao. Thereafter, the matter should have been come by on March, but it was not coming. So, my lord, I mentioned this matter, and in the meantime, certain thing crops up, some urgency, my lord, crops up, my lord. For that, I am being the special officer, need some permission from your lordship to do this thing. So, my lord, I have in the meantime to.
What is the urgency?
Urgency is there, my lord. Lordship, it will take some time. So, my lord, if everyone is accommodating me, my lord, then can your lordship?
If there is an urgency, then come in the form of an affidavit detailing what things are urgent.
My lord, let the matter may I submit, my lord, one thing? I'm the special officer. I'm nobody. It is their property. My lord, let the matter appear on Monday, my lord, and hear it out, my lord. And there are 4 applications: GA40, GA41, GA39. All this matter, all analogous matter, my lord. That is the thing. And I'm
after vacation.
My lord, my
My lord-
application is 42, my lord, GA42.
After vacation, not before
After
that.
appearing, my lord, I am filing affidavit of service, my lord. Then there shall be direction. I am praying for my daughter's marriage. I am for the defendant number 1. My daughter's marriage is to be held on 15 July, my lord. In the meantime,
Okay,
I want.
15. If it is 15 July, it can come immediately after reopening.
My lord, in the meantime, prior to that, I have to purchase something. That's why money I am praying for, my lord. From
That doesn't mean I have.
We
to give
don't
it
have
to
any objection, my lord. I am respondent number 4. We don't have any objection to this.
I have to accommodate to you.
I have no objection, my lord. If her daughter marriage is here, my lord.
So far as the dispensation of money, we don't have any objection.
I am for the.
It did though.
6 lakhs I have paid for, my lord, for the daughter's marriage expenses to meet the expenses urgent matter.
My lord, there is a partition suit, my lord, between the brothers and sisters.
13th.
13th June.
13th May.
I'm ready.
13 May is on Monday, my lord.
Yes.
My lord, all the matters are coming, my lord.
Today is
13th May to 14th to পেরিয়ে গেছে 13th June হবে 13th
May.
June হবে
Today we are on 15th.
Sorry. 20.
Guardian actor. Devraj.
Whenever your lordship is short matter, 5 minutes matter.
ও তো দিচ্ছেন তো উনি
Every matters are supposed to be very short, but it becomes long. And I have to accommodate each and every one.
I appreciate.
So far as the dispensation of
Keep it 21.
21th of May. Obliged.
21st May, my lord, lordship.
Obliged.
Item number 3.
Yes, the application GA16.
My application.
Yes.
My lord, this is an application for substitution because defendant number 3, my lord, has died, my lord, very recently. My lord,
Have you any objection?
But I'll
13th
tell you,
April
Lordship, my lord, only
2024.
one, my lord, technical difficulty that I am facing, my lord. I'll leave it to your Lordship, my lord, what to do about it. My lord, this application, my lord, has been taken out by way of master summons. But my lord, there is no affidavit to that effect, my lord. If your Lordship kindly sees the application, it should be, my lord, affidavit in support of the master summons, my lord. There is no affidavit to that effect, my lord.
Affidavit is there.
Well, it's a verification affidavit, which is, my lord, by way of notice of motion. There is no affidavit to the effect, my lord. If your Lordship kindly sees.
Master summons. Master summons is also. Master summons is there.
So, my lord, master summons, my lord, has to, my lord, follow with a supporting affidavit. And it has to be, my lord, in the form of an affidavit, my lord. This cannot be, my lord. They have to, my lord, perhaps, my lord, withdraw, my lord, and come up fresh, my lord. Not in the proper form, my lord.
You file it.
But it is very technical, this thing.
Yes,
my
but
friend
file
has
it
taken
afresh.
Oh.
File it afresh. Withdraw it. Liberty is given to withdraw the application and file it afresh.
Deeply.
Withdraw application GA 16 of 24 and file afresh. File it immediately.
Yes, yes.
They will, otherwise they will have no objection.
In course of the day, I shall
Yes.
try to find.
Item number 4.
I'm opposing this application.
GA5.
I am for the plaintiff. This is my application for injunction. Your Lordship would recall, your Lordship has already heard Mr. Gupta on this. Lordship, I am a tenant. I am a tenant in a property being room number 7 and 8 at 40 Park Street. Lordship, I was in possession since 1970s. Mr. Gupta. Lordship, late 70s, I let out the I sublet the property to the defendants, to the father of defendant number 1. There were breach on his part as regards his obligation as the subtenant. I
By
filed a
order of
suit.
the court, you got back the
Yes,
possession.
Lordship, I got the possession.
But subsequently, numbers were changed.
Yes, Lordship. In 97, the property was under lock and key. I discovered that that some of the respondents, being 2 to 14, have barged into the property, broke open the locks, and they have taken possession. I apply since the executing court had handed over possession. After I filed an application saying that my possession has been taken away. So the the honorable court was pleased to record that since the decree has been satisfied, the executing court has no further locus. So I was advised to file a further suit. I filed this suit in 2015. Lordship, the suit initially was marked as undefended. Thereafter, we took out an application for appointment of a special officer commissioner for the purpose of ascertaining who is in
I remember
possession.
the fact. Now you have come with an injunction application.
Yes, Lordship.
So that they cannot hand over the possession.
Yes,
to
Lordship.
anyone.
So that they can further not transfer the property to someone else, because
not to create any third party.
Yes, Lordship.
That is your point,
Yes,
Mr.
precisely,
Gupta.
Lordship.
That you have submitted. Now let me hear Mr. Ghosh.
I possibly would be in reply to Mr. Ghosh's submissions.
If I may
His
just
contention-
refresh my
The
client's
point is
stand.
you are inducted as a tenant by the landlord itself.
Yes, by the owner, and my lord, the very basis on which they are enjoying the interim order, my lord, is from the records will be seen is to be incorrect, because the very basis, if you page 31 of the affidavit in opposition, was that, my lord, we have come without the knowledge of the tenant, and there has been, my lord, and that we are possessing the property illegally. To my lord, my submission would be prima facie. I have shown documents which is annexed to the affidavit in opposition, showing that my entry is legal because the landlord has given me consent to assign, and the landlord has also, my lord, provided for the my lord factor that whoever is the assignee will be treated to be the tenant of the original landlord. So, my lord, my entry is
Your
legal.
entry is under legal title.
If my entry is
not
legal,
illegal
my lord,
possession. That's your point.
I cannot be a trespasser. And my lord, the landlord would obviously have a better right, title, and interest over the property than that of the tenant, who is admittedly the plaintiff. The plaintiff.
What is the stage of the suit?
My lord, that I am not a.
This suit is proceeding as an undefended suit against defendant numbers 1 to 11. The added defendants have filed written statement. So that is the stage of the suit right now. But
Because I'm in possession now, the others would not be interested.
I have been able to understand my learned senior friend's submissions, my lord. He is claiming, his client rather, is claiming, my lord, interest in the property from the owner. Now kindly sees the application once. This makes a very interesting read. But what happens is, my lord, pursuant to orders of this honorable court, the commissioner is appointed. The commissioner pays a visit to ascertain who all are there in the property. Kindly takes a look at page 35. The minutes are recorded. The security guard on the ground floor says flat 7 and 8 was there. It has been defaced. Now at page 39, they say
There might be a renumbering, but you suspect
renumbering. That is one side of the story. The second side is the owners are present. One Mr. Aditya Karnani was present at page 47. Kindly sees that document once. The owner says, I do not know Fairland. My learned senior friend's client. We have never inducted him. Kindly sees page 47. This is the minutes of a meeting of a site visit held on 21st April 2023 at page 47, my lord. Has your lordship got it, my lord? 47. Yes. Now, if your lordship kindly takes a look at serial number 5, kindly sees the presence.
Aditya Karnani.
Yes, that's the owner, director of.
Structural change inside the premises.
Yes, kindly, my lord.
Which
Then,
first floor? In the first floor, which possibly
this is the
for
property
that
in the
7
first
and
floor.
8 become 9A.
Yes. Now, kindly sees second sentence on the first floor. He says, as per his submission, there is no existence of flat 9A. And he don't know who is Fairland Group. His tenants are Turner Morrison. And flats who are the plaintiff. And the flat number 7 and 8, there is no existence of flat 9A.
That is page 47.
Page 47, my lord. If your lordship kindly takes a look at the application, page 47, my lord. Typed copy of the minutes. The minutes it is 45. The typed copy is at 47, my lord. Now, this makes a very interesting read. My lord, the owner of the property says it was flat 7 and 8, not 9A. And the tenant is the plaintiff herein. And they do not know who the defendant here is. So, my lord, all my submission is today that, my lord, good, bad, indifferent, my lord, this is what the position is there. So, if there is a further transfer of the property, then that would create multiplicity of proceedings. So, my lord, all we seek today is, my lord, injunction till the disposal of the suit. It may so happen that my learned senior friend would, in the trial, would be able to prove something better.
All right.
So, my lord, as of now, my lord, the suit property should be protected and no further third-party interest. So, once the landlord is, the owner is saying this, then this creates a difficulty because the other deeds then are questionable documents then, which your lordship will adjudicate at trial.
All right.
Those are my submissions.
My lord, 1 minute only. This is something that Mr. Gupta had not, my lord, brought to your lordship's notice on the last occasions. My lord, then, according to Mr. Gupta, I am a trespasser. If he is relying on the statements of the owner, that can I be said to be a trespasser? I am a subtenant of Mr. Gupta. He is admitting that. Your lordship will kindly see what is being said. According to Mr. Karnani, who is the owner, their tenants are Turner Morrison Limited. That is admitted. Who have sublet the premises to Fairland. That is our client. So, my lord, if the owner's contention is to be taken to be correct, I am a subtenant under Turner Morrison. So under those circumstances, my lord, when he's relying on the owner's statement, I put a question to myself, can I be said to be a trespasser? It is the only ground on which this order has been passed on 31st of July, page 31. And my lord, the documents will speak for themselves. I have dealt with the documents specifically. I have said that the director of Karnani Properties has given me the assignment deed. They have not denied that in their affidavit in opposition. There is no denial of the fact. So, my lord, non-denial and non-travesty of a particular, my lord, case is admission.
All right.
Your lordship will kindly also consider that.
2 sentences in reply, if your lordship kindly permits. My lord, firstly, at this stage, the owner has disputed their induction. Secondly, they have not showed any document that they have come under me. So, as of now, all I seek is that do not further transfer. You're there.
All right, I will go through this document.
I have come under the owner.
Order.
As on date, my lord, the owner is wanting charges for maintenance of the building from us. If your lordship so wants, as on May, they are taking the advantage of sharing the burden of maintaining the property. We cannot both speak together. My lord, if your lordship so wants, my lord, I can file a supplementary affidavit showing that the owner is wanting a portion of the money for maintenance of the building from my client. I put a question to myself, can I be considered to be a trespasser whom the owner is wanting to share the, my lord, the burden of maintaining the premises. And I've been doing that. I've got vouchers. Since long, I've been doing that. Repairing of the building, keep maintenance of the building, all are being shared amongst the occupants of the building. The owner is writing letters. There's a letter of month as in the month of May also.
All right.
We cannot blow hotel code at the same time.
But the injunction subsisting interim order is still
I'll
delay.
check it.
If it
I
could
have
be
to
till
reserve it
disposal,
till further order, if I may be able to pass
then
the
till
order
disposal
itself.
kind.
Yes.
Grateful.
Item number 5 and 6.
My lord, I appear for the defendant number 1. My lord will remember, my lord, this is a partition suit, my lord, where we had all raised a question on the valuation because it was it had taken place quite long. Now, long back, your lordship had directed the registrar of assurance to provide a valuation report. My lord, and your lordship had also given us liberty to peruse the same. Now, my lord, we have perused the same, and my lord, we have also applied for a certified copy. My lord, until unless, my lord, the certified copy is with us, my lord, it will be a bit difficult for us to make any submission.
Only one humble submission. I appeal for the plaintiff numbers 3A and 3B. My lord, what had happened was a partition commissioner was appointed and he has filed a report giving X as the valuation. Now, since it was
For selling a property.
for selling different properties. So, my lord, since that report was a few years back, it fell from your lordship on our submissions that it should be, your lordship should call for the valuation from the registrar of assurances. That is what the report which my learned friend has appraised your lordship of. But whatever be the valuation, we have taken inspection of that. So whatever be the valuation, my lord, what my clients humbly beseech, that my lord, the properties could be put up for sale and that valuation could
Unless
be given
there
as
be
the
valuation, there cannot be proper actual order.
Absolutely.
It should be done. Without valuing in property, I cannot say let it be sold.
No,
At
the
whatever
valuation
price.
is there
Let it
given
come.
to my lord. So my lord,
Let it come on the next day. I will consider it.
and if it could be next week, my lord, then the order for
No,
sale
not
would be
not
passed.
next.
Only
next
for
week.
the
Why
order
all the
was-
matters on next week?
As your
I
lordship
will fix it on 20 at your own risk.
20th has gone out.
I will fix it on 20. But that will be your risk. Because if I'm not able to take up 20, because none of the single staff will come on that date. They have their election.
Oh, elections. Okay. Very good. Right. But whenever your lordship's business permits.
Adjourn to 20th June.
Grateful, your lordship.
The moment you ask for early date of hearing, I will postpone it.
My lord, instead of 20th, my lord, can it be on
27 June.
Grateful.
Yes.
There is an order to take the valuation profile and give to my personal person kindly liberty to inspect the file once.
You are for?
Defendant number 6.
The learned counsel for defendant number 6 is given liberty to inspect the record.
Record to
Inspect the record in terms of
the valuation.
the original site rules.
Grateful.
Item number 7.
My application, my lord, your lordship. Yesterday, my lord, we mentioned that matter, my lord, this defamation suit of my learned friend.
Yes.
We had filed an application saying that in the written statement we had relied upon a report of the Office of the Registrar of Companies. That is my justification for publishing that telecasting that program. But that original document is not with us, and we could not give them inspection of that document.
Where is your WS?
WS is already filed.
No, is it annexed?
No, we have not annexed that. We have. We have referred to the report. If your lordship kindly sees, we had given them inspection. Kindly see page 25, 7th September. We had provided them with a copy of that inspection report. 7th September 2023.
Yes.
Now, then, my lord, kindly see, thereafter their reply comes at page 26 that there was one page missing and therefore they could not take inspection of that document. So, my lord, therefore, my lord, we filed this application saying that the original report is in the office, is from the Office of the Registrar of Companies. Let that office produce that document before your lordship. It is a document which is not in my power and possession. It is therefore It is only the disclosure of the document.
Yes,
which
Mr.
we are
Ghosh.
Yes. Well, first of all, this document was not disclosed in the affidavit of documents. I've got my learned friend's affidavit of documents. They have only
But you have
relied
asked
on
for this document.
2 emails.
Right, but you have asked for this document.
No, I have not asked for this document.
Who asked for
There
this?
is an order of September 8. Kindly see.
I'll come one by one, Malad. I'll
Just
show.
one second. I'll just show the order, Malad. Page 18, your lordship will see the order. Whatever documents we have disclosed, that admission denial was done. Then, Malad, I made a prayer before the Honorable Justice saying that we have want to disclose another additional document, and we have served the copy to the council for the plaintiff. So they were given in liberty to take inspection. At the time of inspection, they said that there is one page which is missing. And therefore, Malad, we said that let the original come.
Yes, Mr. Ghosh.
Yes, we have not taken inspection because when they forwarded us a copy,
one copy was
before asking for disclosure, the judge has said that if you want to rely on any document, show it to them. They couldn't show us the document because it was incomplete, the copy they gave us. And that was in 2023. Then this application was filed. My learned friend has earlier an order has said that he will not press for prayer A. He only asked for prayer B. That's recorded in November, one order. So they just want to issue a subpoena. This document is not in the...
That is an alternative prayer.
But that you've conceded. It's written in my affidavit.
No, one order is production of the document.
Yes.
But that document has not yet been inspected by you since one page was missing.
Yes. So now they want to subpoena the original document from the Registrar of Companies. Now, this document, my lord, is not, neither am I the author, nor is he the author of this document. So they will have to prove it in the first sense. But my submission was, my lord, first that it has not even been a disclosed document. In the affidavit of, if they had it, well, they would have had it if they at the time of making this program, if they had the document, it would have been in their possession. Now, our main grievance is, my lord, that will also be in the suit, that they could not have got. This is not a public document. So this is not a public document, number one. Number two is, if they have to get it, why should they get
Is this report in the disclosure document list?
No, it's not there here.
It cannot be.
Later they have tried to give it.
Because I wanted to file this additional document. Court gave me that liberty to file additional document. Your lordship will kindly see that order.
Additional document, but after inspection.
So that is what I am saying. This document.
So you call for the original, you write to that department that this page is missing.
Yes, why should the assistance of the court will be given?
I am saying, under, kindly see, have a look at order 6, order 16. Order 16, rule 6,
Whatever that might be, that you have asked for a document and that document is supplied to you. One page is missing in the document.
Document is not my original document. Document is a Xerox copy which I have. I do not have the original. So I am saying that office be directed to produce. It is
but they would not be getting inspection of the document.
He will. Once it comes, he will get. I will also take inspection. He will also take.
Two things are there.
Yes, my lord.
If I ask someone to come and depose with this document, they will not given any opportunity to prior inspection of these documents.
No, my lord. That prior inspection will arrive. This is, kindly see, this is a stage of disclosure. This document is not going to go in evidence.
So I am giving an order that they may be given, that this department may be given a certified copy of these documents to you on application.
No, that cannot be done. Their prayer is that the department will come and give the document
in that case, problem
to
is
the
that
court. How they will prove this document is their so there's no question of certified
they will not
copy.
get prior inspection of this document.
There is no question of prior inspection. Once the document comes, they will get inspection. Kindly
So
consider.
there is no explanation why this document was not given in the affidavit of documents.
Kindly consider.
This order was that the previous order of this court, plaintiff has liberty to inspection of additional document disclosed.
Yes.
Counsel for the defense.
Now I have to give a go by to this order.
Liberty to take inspection. This inspection is, kindly see your provisions of the code. Inspection is post discovery. We are at the stage of discovery. Once the document is discovered,
then you call for this document from the department, certified copy.
That is the order which I am seeking formally, that the department will come and produce that.
Two things are there. One is department will come and depose here, producing the document, when the document will be marked.
No, document, that is I am agreeing with my learned friend. The document may not be marked at that stage.
Then how can this be?
No, it will be marked after disclosure. Then I will have a chance to
Court
prove
cannot
this.
do that. Court cannot fish out evidence. You have to apply for certified copy.
Well, this is a case of not fishing.
You're not
out evidence.
entitled to a certified
Kindly,
copy.
let us see order.
Come on the next date.
Well, kindly, kindly.
Well,
hear
your
me,
lordship is fixing the. Yesterday, my witness was also here. Any day, your lordship fixes the witness.
Only one.
Let this be pending. Where
It
if
cannot
they
be.
have to prove their document,
If
they'll
that's
have
what you are referring to.
Kindly come to order 16 once. Rule 6. The court has the power for summoning for production of any document from any third party also. Kindly say 6 first. Rule 6.
Mr. Sen, I have to go through all these things. I have to hear other matters will be neglected.
I am not taking your lordship's time. Kindly say, I thought that this was a matter of any person may be summoned to produce a document without being summoned to give evidence. And any person summoned merely to produce a document shall be deemed to have complied with the summons if he causes the document to be produced instead of attending personally to produce the same.
So
I am saying that authority will depute a person only to bring that document to your lordship.
That is prayer B. That's why he had said this before November 20.
So this is order 6, rule 16, and this.
Would you file any AO?
I
Yes,
filed. That's
yes. But in
I
fact,
filed. Your lordship keeps it with the suit. We'll argue this point.
cannot be. You kindly see, I am saying
It's
for
only
next week.
to stall my hearing. That's why.
Come on the next week. Heard in part. Adjourn to 22nd May.
Well, after the vacation, I won't be there.
22nd May. Come.
We won't be there, on
21st, my lord, kindly.
20th.
20th, my lord, kindly.
On the reopening day, my lord will keep it and also fix it for my evidence.
13 June.
13 June. This application, the lordship had said the date your lordship will give
13,
today.
this application heard the GA number 2 of 23 in part. Adjourn to 13 June for further hearing.
And my suit, my witnesses.
That is after this application.
Your lordship said yesterday that today, because yesterday we only mentioned the matter.
The witness action will be taken up after disposal of this application. 8.
Item number 8.
Here for the plaintiff, Milord. This is my applications for Milord striking of Milord the defense of Milord the defendant number Milord 1, 2, and 4.
Where is the application? What are the grounds?
Milord, the grounds is that if your lordship, my lord, first takes Milord page 7 of the applications on January 5, 2024, Milord, there was a directions for Milord the discovery and inspection. Milord, we have communicated, my lord, find at page 7, Milord.
Order 11, rule 12, yes. But how have you demonstrated that these things are not complied with?
Yes, Milord. That's
But have you stated this?
Yes, Milord. My lord, you'll see that on and from paragraph 3, Milord, I have stated. The petition states that by an order dated January 5, passed by Honorable Justice Krishna Rao, suit was directed to be proceeded undefended against the defendant number 2, 3, and 5. It was further directed that the parties to complete discovery and inspection of documents, filing affidavits of admission and denial. Then, Milord, the petitioner states that the plaintiff, under covering letter dated January 25, 2024, through his learned advocate, served a copy of the affidavit of documents upon the advocate of the defendant and requested to have the inspection of the document relied upon by the plaintiff. By the said letter, it was also requested to the advocate for the defendant to serve a copy of the affidavit of documents on behalf of the defendant. But in spite of the said order and the letter, the defendant failed and neglected to comply with the said order. The advocate for the plaintiff thereafter served a notice on 2nd February 2024 in reminder for compliance. Petitioner states that thereafter the matter appeared on February 9, 2024, but none appeared on behalf of the defendants. When his lordship, the Honorable Justice Krishna Rao, was
So it is undefended against 2, 3, and 5.
2, 3, and 5.
So far as 1 and 4 are
they have filed a written statement, Milord, but they have not disclosed document. Thereafter, Milord, this honorable court was pleased to, Milord, close their discovery and inspection.
Where it is that?
Milord, yes. If your lordship kindly see, Milord, the order dated 9th February 2024, Milord, at page 11 of the application, and it's a C. Instead, what is it? Census none appears on behalf of the defendant by an order dated 5 January 2024. This court has been directed to the parties to complete the discovery and inspection of documents, file the affidavit and admission of denial to exchange the suggested issue. Counsel from the plaintiff had handed over a communication dated 25th January to and 2nd February, wherein the plaintiff has forwarded their affidavit documents and requested defendant for inspection of the documents. But in spite of receipt of both communication, defendant number 1 and 2 failed to come forward either for inspection of documents of the plaintiff or to disclose their documents for inspection of the plaintiff. Let communication be kept with the record. The plaintiff has filed affidavit of documents. Let the same be kept with record. As defendant is not interested for inspection of the documents of the plaintiff and disclose their documents for inspection by the plaintiff, the scope for disclosure of documents by the defendant is closed. In these premises, my lord, I have filed this application seeking, my lord, since they have on 2 occasions, my lord, fails to, my lord, comply with the direction, my lord, now they are, my lord, I am entitled to an order under, my lord, of striking order. My lord, if your lordship kindly see, my lord, order 11 rule 21. Lord, non-compliance with the order for discovery, where any party fails to comply with an order or to answer the interrogatories or for discovery or inspection of documents, he shall, if the plaintiff be liable, to have the suit dismissed for want of prosecution, and if a defendant to have his defense, if any, struck off and to be placed in the same position if he had not defendant, and the party interrogating or seeking discovery for inspection may apply to the court for an order to that effect, and an order may be made on such application accordingly after notice to the parties after giving them a reasonable opportunity.
Yes.
Lord, I have filed this application, my lord. I have given notice. There was a direction to file affidavit, not filed, my lord. Today, my lord, I am seeking, my lord, an order.
Yes.
My lord, I am further responding, my lord. I like to use affidavit because your lordship will see that the date of dependent number 3, my lord, that is 27th January.
How can I know date of defendant number 3?
Dependent number 3 is the mother of dependent number 1 and 4. Manju Jaiswal. And prior to her death, my lord, that Manju Jaiswal was admitted in the nursing home for a month. And the dependent number 1, who
have you filed any AO affidavit in opposition against this?
There was a direction given, they have not filed.
My lord, I am for dependent number 1 and 4, my lord. My lord, dependent number 1 was looking after his mother, and he was busy with her. I
do not like to hear any story right now. Have you filed any AO or not?
My lord, I want to use affidavit against this application, my lord.
Within 7 days. The learned counsel for the defendant number 1 and 4. Please leave to file affidavit in opposition. Leave is granted. The same shall be filed on or before the returnable date. The same shall be filed within 2 weeks. Affidavit in reply, if any, within 1 week thereafter. The matter will appear in the list on 21st June.
My lord, would it be your lordship's pleasure to grant them as the last time, because this reaction was there already, your last occasion. On the last order, if your lordship sees, my lord, the last order, the direction was already there. They have not complied for affidavit in these applications.
My lord, that's the reason I could not communicate him. And he also...
Come on the next date.
My lord.
Your fate will be sealed on that date or decided.
Great.
Item number 9.
No further time, no further time shall be allowed. File affidavit in opposition.
Item 9, I beg to appear on behalf of the respondent number 5. My lord, earlier occasion, they might have completed their argument and our not. They have not yet completed.
Maintainability point is to be argued.
Yes, maintainability point, my lord. My lord, before they start arguing their application, my lord, I just want to show one section of charitable.
Let them argue first, then I will hear.
Section 9.
When your turn will come,
yes,
you reply. Yes, Mr. Ghosh.
Yes, ma'am. Lordship will recall, my lord, this is my application for setting aside your lordship's order, my lord, of dismissal. The application under the religious and charitable.
It was not exactly dismissal. You could not file any Vakalatnama.
Yes. It was not that. Yes. My lord, there were 3 trustees, those who had made this application.
2 expired, 1 was remaining who did not file Vakalatnama.
Yes, my lord. Yes. My lord, now my client is one of the present trustees. He's not a party. Your Lordship will kindly, yes, he is a trustee.
Let me
He's
let him
not an
submit.
interim trustee,
Let
he's
him
a
submit.
trustee. He's not an interim trustee, he's a trustee. Your Lordship will kindly come to page 38 of my petition. First volume, my lord, there are various volumes.
38. That was the order.
Yes, my lord. Yes. This has been, my lord, your Lordship's order.
Yes, I can remember this.
Yes, my lord. So, my lord, as has fallen from your Lordship, that inasmuch as the existing trustee of one of the trustees, my lord, had failed to file the wakalatnama, your Lordship was pleased to pass this order. Now, my lord, your Lordship will kindly see how my client is connected. Pages 96 and 97, your Lordship will kindly see once. Same volume, my lord.
96.
Yes. My lord, admittedly, your Lordship has got that, my lord, 96. Jagadish Prasad Tulsian, my lord, was the principal trustee who is no longer there. Mr. Shakkoshen's client is claiming to be one of the heirs of Jagadish Prasad Tulsian. My lord, he appoints Ram Avatar Banka, who was my father. Mitesh Banka is my client now. Ram Avatar Banka was my father. And my lord, he was one of the trustees. And thereafter, my lord, in 97, your Lordship will kindly see page 97. One Rajendra Kumar Banka.
Also in page 97.
Yes, my lord. Your Lordship has seen 96 is with regard to Ram Avatar Banka. And my lord, 97 is with regard to Rajendra Kumar Banka. One was my father, who has passed away, and one was my uncle. Both passed away, my lord. The third one failed to file the wakalatnama. So, my lord, these people, my client is connected with these people who are the erstwhile trustees appointed by, admittedly, the principal trustee. So, there is no dispute with regard to my lineage as such. Then, my lord, your Lordship will kindly see the appointment of the...
Presently, you are not the plaintiff number 3, the petitioner number 3.
No, no, no. I'm not. I'm a non-party. I'm a non-party, and that is what was considered by the Honorable Supreme Court. And the Honorable Supreme Court has been pleased to pass an order, which I will, my lord, bring it to your Lordship's notice later. My lord, page 99, your Lordship will kindly see. My lord, one by one, I'm coming to you. Page 99. My lord, this is an order by which, my lord, the three disputing groups, one from each disputing group was appointed as interim trustees.
Where it is mentioned?
Yes, ma'am. Your Lordship, 1, 2, 3, 4 lines from the top, my lord. Fourth line. I accordingly, yes. I accordingly direct that pending disposal of the interim applications, the plaintiff number 1, defendant number 1, and the power of attorney holder of defendant number 4, namely Chakradhar Lal Agarwal of 1 such and such, will function as interim trustees in respect of the concerned public charitable trust. The aforesaid interim trustees will function under the supervision of Mr. Deepak Basu, learned senior advocate of this court, whose decision shall be final in the event of any dispute amongst the said interim trustees. And for such purpose, Mr. Basu will also act as a trustee for the time being.
You were a party there in Rajendra Kumar Banka.
Yes. My lord, Rajendra Kumar Banka was one of the interim trustees. Mr. Shakkoshen's client was one of the interim trustees. Yes, she was represented by the power of attorney holder. And my lord, another party by the name of Mohesh Tulsian was also an interim trustee. My lord, the very important fact is, your Lordship will kindly consider, Justice Shomanta was pleased to make this, my lord, arrangement on the basis of the pendency of the disposal of interlocutory applications. My lord, these interlocutory applications were made in a suit, which ultimately got dismissed. My lord, when this suit got dismissed, automatically all the entering applications also got dismissed along with the suit. We brought it to the notice of the Honorable Court that inasmuch as the suit got dismissed, my lord, this arrangement cannot in any longer stand and continue, inasmuch as that was the consideration. So, my lord, all these interim trustees were, my lord, they were set aside. They were not directed not to continue as interim trustees, apart from only Rajendra Kumar Banka, my client. But, my lord, the Honorable Court was pleased to continue with the supervisory trustee, inasmuch as there were dispute amongst the three groups. Then, my lord, Mr. Sen's client and the other group, they all preferred appeal.
Against this order?
Against this order. There were various appeals, my lord, in all forums of this Honorable Court. Then, my lord, at orders which are there at pages 104 and 111, I'll just indicate that. This Honorable Court repeatedly, my lord, labeled them as interested persons. 104, your lordship will kindly see. 104.
It starts at 104.
Yes, I'll take your lordship to, my lord, the relevant portions. 104, your lordship will kindly see. It's a division bench order. Your lordship will kindly come.
Just sorry to interrupt my learned friend, but this application is in the nature of a recalling application.
Yes, the background has to be the background has to be said. I know why my learned friend is so worried about it. It is very important. At all whether they can raise.
Don't interrupt, please.
At all whether they can raise any dispute with regard to this or not. My lord, page 107, your lordship will kindly see.
Yes.
The last line. The respondents applied for certain direction with regard to the working of the trust. The court is entitled to hear any objection that may come up from any person. Section 7 would permit the court to give information and a direction in respect of the trust, and if necessary, upon hearing the persons interested in the trust. My lord, so your lordship will kindly see that the Honorable Division Bench was pleased to take recognition of the fact that persons interested in the trust would be given some hearing. Then, my lord, page 111, your lordship will kindly come. Their status, your lordship will kindly see that they are raising an objection. Whether they are entitled to raise any objection for the purpose of putting a banner in the good work of this trust. Who are they? Your lordship will kindly see at page 113. This is another division bench. Another division bench order, my lord. Various division benches have passed order.
Yes.
Page 113. Mr. Shivratan Kakrania, my lord, Mr. Shivratan Kakrania was representing Mr. Shakoshan's client, the same group. Advocate appearing for the appellant would contend Saroj, that is their client, was the only surviving heir in the family that created the trust. She is quite interested in the estate. Moreover, Saroj never claimed in her affidavit she was the principal trustee. Hence, question of disapproving a contention as trustee and a principal trustee would not arise like the case of Mahesh. Mahesh is the other group. The learned judge failed to appreciate the stand of Saroj. The learned judge should have disposed of the pending applications filed in earlier point of time before taking up the prayer for modification at the instant of Bankas, that is our client. Then, my lord, your lordship will kindly come to page 115. I'm just taking to the relevant portions, my lord, the relevant portions. My lord, first 1, 2, 3, 4, 5, 6, 7. 7 line from the top. Saroj being an interested person and the parties already having accepted such interim arrangement since 2002, we should not disturb her present status of Saroj. However, we make it clear. Yes. My lord. Make it clear such interim management would not give any special right to Saroj to claim as trustee or principal trustee or any other special status that she does not have otherwise. So, my lord, your lordship will kindly see that Saroj has been, my lord, declared to be an interested person. Same as that of Mahesh Tulsian, the other group. There are 3 groups. My lord, from this order of Saroj, Mahesh Tulsian had preferred an appeal. And the Honorable Appeal Court has again held that whatever status has Saroj been given will be given to you. And so both have been declared to be interested persons. Now, my lord, their main grievance with regard to our having made this application is that, my lord, we are at present a non-party and that there is no list pending because we had the ACR has got dismissed. My lord, in one of the orders from this ACR, passed in this ACR, there was a appeal pending before the Honorable Division Bench. When, my lord, the ACR got dismissed, we brought it to the notice of the Honorable Division Bench that the ACR has got dismissed, as a result of which all interlocutory applications that has been passed and orders that has been passed should also be vacated. In one of the interim orders, my lord, the appointment of supervisory trustee was there. So, my lord, we brought it. We felt that it was our duty to bring it to the notice of the Honorable Division Bench. We brought it to the notice that the appointment of supervisory trustee.
Right. Is there any document to say that you are interested?
Yes.
Where is that?
Yes, yes. Your Lordship will kindly come to page 118.
Yes.
I'm a trustee. The interim arrangement was made only for the pending application. I am undoubtedly and admittedly a trustee. Your Lordship will kindly see. My lord, page 119. I'll not take to the entire order. My lord, this application was made by my client to get in as an interim trustee in place and stead of his uncle, who was the interim trustee because of his failing health. Your Lordship will kindly come, my lord, to the last portion. To borrow the expression, my lord, the second last paragraph at page 119.
Yes, I've got.
To borrow the expression of the Honorable Division Bench while allowing the appeal of Saroj.
Say two persons are interested.
Yes, interested. And then, my lord, the last would argue that the Honorable Division also recorded is all this is there. My lord, then, my lord, your Lordship will kindly come to page 120, the last portion. That's the most important portion. Under such circumstances, the order dated 13th May 2002, that is the order that I showed, my lord, the arrangement with regard to interim trustee, my lord, Justice Samanto's order, is modified to the extent that Mitesh Banka is appointed as one of the interim trustees in place and stead of Rajendra Kumar Banka. Mitesh Banka is my client. He was then appointed as an interim trustee in place and stead of his uncle, who was not wanting to continue because of failing health. My lord, now the interim trusteeship has gone, but I am a trustee. As a trustee, my lord, I want to continue with the good functions of this trust.
How you can say you are a trustee still now?
My lord, I have been appointed by the other two trustees as a trustee. I've got that
you showed.
That I've got that appointment. I'll tell you, appointment চিঠি আছে এখানে আমরা annex করেছি. Yes. Knowledge. My lord, the letter of appointment, I'll come to that. My lord, the Honorable Supreme Court has been pleased to recognize me. Then, my lord, your Lordship will kindly come to page 121. They preferred an appeal from that order of my appointment. And this is what the Honorable Appeal Court has held. Page 121.
Yes, I've seen that.
The application cannot be entertained since there is no apparent error on the face of the record. If parties are aggrieved by the impugned order, they are at liberty to challenge the same before the highest court of law. The application is dismissed. So my appointment as an interim trustee at that point of time got confirmed. Now, my lord, coming back.
Subsequently, you are relying your power not as an interim trustee?
As a trustee.
Where is that?
Yes, my lord, that. My lord, we have got that letter of appointment, but inasmuch as that has not been germane with regard to this application, we have not annexed it here. My lord, we can produce it by way of a supplementary affidavit. No, my lord, but your lordship will kindly allow me to place a Supreme Court order, my lord, on the basis of which.
Is it in second volume?
No, that is on page 463, yes. Before that, my lord, if I may just indicate your lordship with regard to what we have brought, then your lordship will kindly come to the order then, 463. It is on the basis of the order of the Honorable Supreme Court that this application has been made. I got it. Page 463 would be volume 3. It is only in compliance of the order of the Honorable Supreme Court that this application is made. 463, my lord. And we have not suppressed anything before the Honorable Supreme Court. They were there, they got represented. Your lordship will kindly see. For the petitioners, your lordship will kindly see. For the respondents, everyone was there. Is it not constructive res judicata? The points that they ought to have taken there, it has been decided and an order has been passed.
Mitesh Banka, who is Mitesh Banka?
My client. Petition to file SLP is granted. Application seeking leave is allowed at the risk of the parties. heard the learned senior counsel for the petitioner.
So
Taking
right
note
to
that-
intervention is given to you.
My lord.
Right to intervention
Yes,
is given to you.
yes, my lordship kindly see. Taking note that the matter
No,
is pending.
right to intervention is one thing
Yes, my lord.
for audience.
Yes.
Another thing is we have a based right on intervention. Anyone can come and file an application for right on intervention, but your claim is based on the fact that you are a trustee.
Yes.
Where is that document?
My lord, I'll tell you, lordship. I have got the document.
Come with supplementary affidavit. The court wants to know.
Supplementary affidavit,
Yes.
then your
Mr.
lordship kindly
Ghosh,
direct.
hard in part, Mr. Ghosh is given liberty to file supplementary affidavit
Showing his appointment.
disclosing further documents. The matter will appear in the list on 21st June.
My lord, not this time, no, this side of the vacation, my lord.
Not possible. It will not be finished. I have only 1 week time. I have to
Yes,
pass
I
order
understand.
judgments on
I
all these
understand.
things.
I do.
Yes.
More
21st.
voluminous than the main matter now.
That happens.
My lord, we'll file it by the 21st, my lord. Yeah, not 21st. We'll file it by the 21st of June.
Yes. The supplementary affidavit shall be filed on or before the returnable date. Still now, how many matters I have to take up?
Yes, no, that we appreciate. We'll do that.
16 matters I have to take up. How can I take up this?
If a non-maintainable matter is so late.
Yes.
Mr. Banerjee, don't say non-maintainable.
My lord could overhear this.
That is his trump card.
Because your parts is then maintainable.
That is his trump card, my lord. Non-maintainable.
Item number 10.
Item number 10. This is my application on behalf of the defendant numbers 7A, 7B, 7C, 8A, and 8B in a
What is
partition.
J 15, 16, and 18,
Well, that is what
19?
I'm saying. So far as my application is concerned, my application
Who are you?
is substituted defendants who have taken out an application for modification of a subsisting order of status quo in respect of the properties in question.
Who is the plaintiff?
I beg your lordship's pardon.
Who is the plaintiff?
Lordship, I am appearing.
Plaintiff. Well, did I tell your lordship, there's been a little development in the sense my application is ready for hearing. But GA number 19 is an application which has been taken out by the plaintiff, which has been served on defendants, some of the defendants, which have been served on me just today. GA number 15 and 16 has also been filed before your lordship, to which I have not yet been able to file an affidavit. To some extent, I am at fault there because the time has expired. Today, my lord, since all these matters should be taken up one after the other and together, I was praying, kindly give me leave, my lord, to file an affidavit in opposition to GA 15, 16, and 19 in the course of 1 week. And thereafter, keep all the applications after the vacation.
Mr. Bose, the learned senior counsel submitted and prays for extension of time to file affidavit in opposition in GA
15, 16, and 19.
In GA 15 of 23, 16 of 23, and GA number 19 of 24. Leave is granted to file affidavit in opposition. Full stop. The same shall be filed within 2 weeks.
Well, at GA 19, order already passed on large. Is my fault. We have not served. It is due to appear on 28th of June.
All may appear on 28th.
Let all the matters appear on 28th
June. 28th of June. All may appear together.
Within 2 weeks after vacation, affidavit in reply, if any, shall be filed within 1 week thereafter. All these applications shall appear in the list on 28 June.
My lord, I have a similar prayer, my lord. I'm appearing for defendant numbers 5A to 5D, my lord. Opposition, my lord, my time may be extended for 2 weeks, my lord.
You are for
to GA number 19. Defendant numbers 5A to 5D, my lord.
Defendant number 5A to 5B,
my lord.
Is also given liberty to file affidavit in opposition against GA number 18 of
19,
24.
my lord, 19. GA 19.
19 of 24.
My lord.
18th.
The same shall be filed within 2 weeks after reopening. Semicolon, affidavit in reply, if any, within 1 week thereafter. All these applications shall appear in the list on 28 June. 28
I'm
June.
praying for leave to file my reply in GA number 18, which is ready and affirmed.
Affidavit in reply in GA number 18 is filed.
On behalf of 7 ABs. 7 ABs.
On behalf of defendant number
7 A, B, C.
7A and A, B, and C.
I'm very grateful to my lord.
Grateful, my lord.
Item 11.
Lordship, this matter was kept. Your Lordship, on the issue, your Lordship raised an issue that whether this suit should be transferred to commercial division or not. Because there is a loan transaction involved for
Who is the
business
other side?
purpose. My learned friend is there for business purpose.
They give plaintiff.
There are two paragraphs. If your Lordship kindly have a look, paragraph 4 and 5 of the plaint. This is their own averment.
This is the old suit. 2010.
Paragraph 4 and 5, if your Lordship have a look at their own pleadings. Page 3. In view of the amicable relations between the plaintiff and the defendant number 1, by taking advantage thereof of the defendant number 2, in September
Not in
1996.
usual course of business. I can remember right now.
Yes.
This was not in usual course of business, but
But your Lordship,
in
this
view of
kindly see this
amicable relation between the parties.
Now your Lordship will see the next statement. The defendant number 2 informed the plaintiff that such loan was needed for the purpose of expansion and promotion of business activities.
Absolutely. But
This
the
for promotion.
loan giving was not the regular form of business. Giving loan
Correct.
was not the regular, did not form or do not form a regular business activity.
Your Lordship, this principle will only apply if he has granted the disbursed the loan only for once. His case is that he has been disbursing the ICD from
The amicable relation-
1996 onwards.
It is not in usual course of business. Can you show the article of association versus nature of
That
business?
is not with me right now. That is for the
Then-
plaintiff to produce. Otherwise, if anyways, your Lordship will look at the judgments.
It is in the plaint itself for amicable relationship. This question may be kept open for preliminary hearing.
Has said that out of amicable relationship with the director or one of the director of the defendant
That-
company
these are question
and
of
the
fact.
plaintiff, the loan
So
was granted.
these are question of fact. This kept open as a preliminary issue. This can be heard.
Yes, your
Prima
Lordship,
facie, it cannot be said. These are dispute involve commercial ones.
your Lordship will also see this is the judgments of our Calcutta High Court. I am carrying those judgments. Your Lordship directed us to file notes on this. Starting from Lady Moon Prime High Tech and
Number of
it's-
matters are there. There are also other judgments when by Justice Bashak when loans are given for a friendly relation, out of friendly relation. Then that is not because whether this loan was given in usual course of business and whether they had a financial company whose regular duty was to give loan. Not that. It is stated amicable relationship.
Your Lordship,
Anyway, mixed question of law and fact kept open.
your Lordship is keeping this issue open.
Yes, I'm not closing it.
But I'm carrying those judgments which says that
Come-
if the
come
business
at
is
the
only a
time.
hand loan, then it's not for commercial purpose.
That is to be established
That is established from the pleadings itself.
by evidence. We have to construe an article of association and all these things.
Your Lordship, otherwise, in any ways, this is a separate application filed by them for initiating perjury. Your Lordship can hear it out. Pleadings are completed. Perjury, they say only on the ground.
This matter be disposed of first.
No, your Lordship,
This is the application for
no, Lordship, this is an application for 340. This is ready for hearing. Yes. Their application.
GA5.
Yes.
So this will not go to commercial division. Let me pass order in this respect. Mr. Banerjee, the learned counsel for the defendant.
Defendants, yes.
Defendant submitted that the instant dispute is commercial in nature. However, on perusal of plaint, it appears that loan was given in view of amicable relation between the parties. Full stop. Whether the instant dispute is a commercial one or not is a mixed question of law and fact and is kept open, which can be considered as a preliminary issue at appropriate stage of the suit. For the time being, suit will be taken up by ordinary civil jurisdiction.
So they can proceed with their application
Yes.
is ready for hearing.
Yes, my lord. My
What
lord,
is the issue of perjury?
yes.
Your Lordship, my
My lord.
reply may be taken on record. We have already served. Reply taken on.
You have already?
Reply to the perjury application.
Yes.
Opposition.
Sorry, opposition to the perjury.
अच्छा तो जाओ. My lord, may I, my lord, place this application, my lord? Now, your lordship will see, my lord, that this is an application under 340 of the CRPC. Now, my lord, what I'm complaining of is, my lord, that, my lord, an application has been filed.
What is false?
Exactly, my lord. I shall place, my lord. My lord, an application has been filed by the defendants. The defendants, my lord, is one of the company and, my lord, one of the individual. Now, my lord, this application has been filed. The prior application, this 340 is, my lord, complaining of the fact, my lord, that a previous application, my lord, filed by the defendants, which has been affirmed by the second defendant as a, my lord, director, number one. In the affidavit in reply, he also says, my lord, he is a director. After a gap of 2 years, my lord, that second affidavit, my lord, was affirmed. Now, my lord, we have subsequently come to know, my lord, that when this application was filed, prior thereto, my lord, in the year 2012, he has already, my lord, ceased to be a director. So, my lord, an person, my lord, affirming and filing an, my lord, affidavit before this honorable court, saying on oath that he is a director, but in reality, my lord, he has ceased to
First
be a
come to
director.
that affidavit.
Yes, my lord. Kindly seize, my lord.
Page.
My lord, I shall first place, my lord, the application, my lord, first. Page 21, it starts. The affidavit portion, your lordship will find at page 36. Kindly takes, my lord, page 36, your lordship will find that this is affirmed.
I am the defendant number 2 and director
of defendant number 1. Kindly takes, my lord, this has been
All right,
affirmed
then-
on 16 December 2019.
Yes.
Now, to this application, my lord, we have filed an affidavit in opposition. To this, to my affidavit in opposition, they also, my lord, use an affidavit in reply. Kindly takes, my lord, the affidavit affirmed on 16 June 2022, which is at page 58. Kindly takes, my lord, this is the last portion of the affidavit. Such and such on June 2022, this has been affirmed. And kindly takes, my lord, apropos this, page 51.
That was shown in by Gauri Shankar Rajgharia.
Yes. He again says, this is, my lord, in 2022. 2019, my lord, first affidavit. 2022, second affidavit, my lord, same stand that I am a director. Now kindly takes, my lord, the master data, which is at page 69. Your lordship will find the fourth entry, name of the company, Inder Chand Rajgaria and Sons Private Limited. Defendant number 1. Director has ceased, my lord, from 2012. This is Gauri Shankar Rajgaria. This has been downloaded from the, my lord, Ministry of the Corporate Affairs. So, my lord, on the date of affirming the application, he was not a director. On the date of affirming the affidavit in reply, he was not a director. Now, my lord, kindly takes, my lord, the nature of the application for once, which he has filed. Page 21, it starts. What happened is, my lord, my examination in chief was going on. My lord, he has come up with this application saying, when those documents, certain documents were exhibited, my lord, he has put forward, my lord, objection to the court, but the court has not recorded his objection. So, my lord, entirely, my lord, a prayer based on, my lord, statement of truth, my lord, of the applicant. Now, my lord, if the application itself, the applicant itself, my lord, has committed perjury, whether, my lord, at all that application should be allowed or not, if allowed, whether it should be recalled or not. That is my second prayer. To that, my lord, my learned friend has used an affidavit. But at this moment, my lord, with regard to the contention, whether there is perjury or not, and if your lordship is ultimately, my lord, satisfied that there is perjury, your lordship will, my lord, refer it to the magistrate. Thereafter, my lord, my learned friend will have, my lord, a chance, my lord, before the magistrate, and he will be audible before them. For this moment, my lord, I shall place, my lord, with the from the application. Kindly takes, my lord, paragraph number 3, which is at page 25. Rather, paragraph number 2, from paragraph 2 onwards, which is at page 20.
As will be evident from question.
Yes, my lord, in the question, my lord, what happened is, my lord, while, my lord, recording the depositions, one of the Millard objection was recorded, which Millard, my learned friend wasn't probably was there, Millard, I couldn't recollect. One of the objection was recorded. Thereafter, Millard, objection put forward, Millard, the Millard Honorable Court, Millard.
Basically, your point is whatever that may be asked or whatever there may be replied, that is no issue. Basically, issue is that when he signed the or shown affidavit, he was not director.
He was not a director.
So first
And
thing
Millard,
is perjury. Second thing, because of perjury, this should be not accepted.
Number one. Secondly, Millard, kindly sees, Millard, the reply which they have given, his advocate on record has given. This is pursuant to, Millard, this is pursuant to a letter, Millard, written by me. Kindly takes, Millard,
Paragraph,
page 78. Paragraph number 2.
My client resigned as director.
Is admitting. Hence, question of any inquiry does not and cannot arise. Hence, there is no such and such. Taking advantage of the typographical error. Millard, a typographical, deepest of respect, Millard. A typographical error, Millard, can occur, Millard, for once. But, Millard, same typographical error in 2019 and 2022.
All right, I got your point. Next year,
and Millard, based on the Millard, the application which my learned friend has filed, that was allowed. So, Millard, I'm seeking, Millard, recalling of that, Millard, order.
Next, I will hear you.
No appeal preferred. Recalling has to be done within 30 days. Not done. No
That will be a next.
Anyways, I will show. For a mere typographical error, perjury cannot lie. It has to be.
Come on the next step.
Fraud has been perpetrated upon the
Expedient,
court,
it is not a
Millard.
fraud.
Come on the next step.
I will.
Millard, may I file my reply, Millard?
Evident reply
That's
filed
not
by
happening.
the learned
Material
counsel
hearing in
for
the
the
adjudication of the case.
defendant.
Millard, I'm for the plaintiff.
Plaintiff be kept in record.
Yes,
Our
I also
GA
filed
number,
my affidavit.
GA number 5 of 24 in part. Further hearing is adjourned to 27 June.
27.
Grateful, Millard. Millard, my learned friend was cross-examining my witness, Millard.
Let this be done first. It will be taken up thereafter.
Item 12.
I appear on behalf of the petitioner, item 12. Where I'm seeking liberty to take out an application for substitution because the plaintiff has passed away on 28th of April, 2024. Millard, the defendant has also passed away, so we'll take a composite
Learned
application.
counsel for the plaintiff seeks for an accommodation
I'm for the respondent
and
number
liberty
7. Your Lordship.
to file appropriate application for substitution. The same is allowed subject to limitation.
Millard, all the parties. Anyway,
Same liberty is given
yes.
subject to law of limitation. Matter will appear in the list on 21st June.
Very good.
Item 13.
My lord, 13, I am the plaintiff, my lord. The suit is against official liquidator. The suit was filed, the company had, my client had let out 3 go-downs to the company. Company had subletted to 3 tenants. Now, after the company became in liquidation, official liquidator represents the company under the Companies Act. Justice Sanjeev Banerjee was pleased to direct my client. One of the tenants became a direct tenant with the leave of court. There's an order. Justice Sanjeev Banerjee permitted me to file a suit against the for eviction of the against the company liquidation against the official liquidator for recovering the other 2 go-downs. Subsequently, the second go-down, that gentleman has also became a direct tenant under me. Only 1 go-down is left. Now, an official liquidator in his report has stated that they have no objection. So, consent decree may be passed. So, I can recover the go-down, and if that subtenant objects, I have a remedy under Order 21, Rule 97. And then the court will pass whatever order has to. But unless I get the decree, I cannot proceed against him. And if I get a decree against the tenant, subtenant has no right. I've got judgments to that effect.
That
So
is settled law.
That's settled law.
Now, how can I say there is a settlement between you and the official liquidator?
No, not
No, no,
settlement.
not-
She's not interested.
It is
She
not a case
submitted.
of settlement, my lord. But we have not been able to take the possession of that particular go down. And that has been also the minutes and everything has been annexed to the report which has been filed pursuant to your direction, my lord.
Let me see the report.
Because they have no
Since
objection.
there
with
was
the
a steep resistance from the other persons, so the possession could not be taken over.
Out of the 3 subtenants, 2 has become direct tenant with the leave of court. 1 with the leave of court, 1 subsequently. Only this 3rd subtenant is not resisting. But I have to get a decree against the main tenant that's represented by the official liquidator.
You have filed this.
Yes, I have already filed it, my lord.
Put your signature on every page of it.
This is the official liquidator's report, my lord. He has
Should be signed on every page. Official, then file a supplementary report. Why all the pages are not signed?
in course of today it will be signed. I will
Or
tell the
file a
official.
supplementary one. Let me have it.
It has been affirmed, my lord. In every case, the official liquidator files a report in this fashion only, my lord.
If the court requires signing it on every page, is there any bar?
No, my lord. If your lordship so directs, definitely the official liquidator will sign in all the pages. If you allow the official liquidator to come today and...
Which tenancy we are speaking of?
There are 2 tenants.
Sham Khaitan, Nandakishore Parekh.
Yes, and the East India Trading, that one.
That is the Ashok Bansali.
Ashok Bansali also become a direct tenant. East India Trading.
No, 3 go downs. Nandakishore Parekh, Sham Khaitan, Ashok Bansali. Ashok Bansali handed over possession to official liquidator.
Yes, and that is
Nandakishore Parekh, Sham Khaitan resisted.
Sham Khaitan is also surrendered possession. Khaitan. Only East India Trading represented by Nandakishore
Sham
Parekh.
Khaitan and Nandakishore Parekh is not under possession of official liquidator. These 2 go downs are not.
Possession may not be, but official liquidator is in custody of the property of the company. It was all 3 go downs were let out to the company. So official liquidator represents the company. Company has to defend.
So let the official liquidator hand over the premises.
Yes, the 3rd premises. So 2 are already given. Only against Nandakishore Parekh, East India Trading. Let him hand over the possession. That decree may be passed. If the official liquidator does not have any objection.
What is the suit for?
Suit for eviction of
Is there any mean profit? Claim of mean profit?
No, nothing.
Nothing. Only
they
I
want
to
the
recover
property
the
back.
go-downs. Suit against the company who was the tenant. Company
So official liquidator shall hand over a constructive possession to the landlord.
Yes.
And actual or physical possession shall be recovered by execution proceeding.
Very well. That's your lordship.
You file a supplementary report.
Yes, my lord.
Liberty is given to the learned counsel, your counsel, or you are the official liquidator?
No. Counsel.
The learned counsel for the official liquidator is given liberty to file supplementary report. Let the matter appear in the list on 19th June for further order.
Very. I'm obliged.
I will pass order that let the decree be drawn up so and so.
Yes.
And the decree be drawn up, put in execution within a period of, say, if the possession is not handed over,
yes,
1 month, 2 months.
I'll execute it and then in accordance with law.
Supplementary report to be filed by the official liquidator, my lord.
Yes.
And all the pages needs to be signed by the official liquidator.
Better.
So the same report, my lord,
yes,
it will be...
you mention that you want to hand it over. You are willing to hand over. Then only I can pass a decree.
That averment should be there.
Yes. Because I cannot force you to give possession.
No. The willingness from the...
Yes.
Deeply obliged.
Item number 14.
I appear for defendants except for defendant number 4.
the different number 4. I appear for the different number 4, Malad. This matter had come up at my instance. Malad, by an order of 1st May 2024, Lordship had granted me leave to file the written statement during the course of the day. There was some delay because the order was not uploaded during the course of the day. That is why we went on the next day to file the written statement. It was not accepted. A further reason was furnished by the department that the written statement has not been executed in the bond paper, which is the rule of this court. Lord, I was only beseeching your lordship if this can be condoned, that everything else is in order. That the department had.
What will be your next plea?
This is my only.
This is this plea is that it is not in bond paper.
Yes, that
The
is the
next
only.
plea? Have you thought it?
But I do not know. The department only pointed out only one defect, which is this bond paper issue. But I know, Malad, this is the rule of this of our court, Malad. But if your lordship kindly condones this, said come from outside, Malad. Earlier also there was some defects which were pointed out, which were cured.
Defendant number 4 has not entered appearance either in person or through learned advocate.
But this is my written statement, Malad, through which, Malad, I will.
That is the report of the department.
Yes, but I am carrying the wakalatnama as well as the written statement. But the department, since these were not accepted, that is why the report of the department is that we.
When the summons was served upon you, and when you were appearing, when filing wakalatnama.
Yes, Malad, the wakalatnama is now dated 17th February 2024. But,
The department is directed to submit a report as to date of service of summon.
Very good.
The learned counsel for the defendant craves leave to file written statement along with wakalatnama. The same may be provisionally accepted subject to final order.
My lord, I'm grateful.
The matter will appear in list on 28 June.
Grateful. But
Item number 26. For arguments. Appeal is still pending. Out of the list. Anybody to mention? I'm sorry, Malad.
Okay now?
Yes, yes.
That you wanted. Yes, next.
27.
In the property.
The item 27, my lord. Here, my lord, I think the matter was mentioned in the warning to your lordship. A request was made. An appeal is being heard, my lord. Today, unfortunately, the division bench is not sitting, my lord. The bench which
Is there any
taking
stay?
the appeal. No, my lord, there is no stay, my lord.
You come here. Cross-examine.
And my lord, the other thing is with regard to if your lordship takes your last order, there was a point which I had raised with regard to, my lord, whether the evidence taken earlier, that is prior to even framing of the fresh issues, whether they will be considered by your lordship or
You
not.
raise this issue. So far as this point is concerned, this court will proceed with cross-examination. You proceed with cross-examination.
No, my lord, that is something else. My lord, that is, if your lordship
That
wants
will
to
be
still
decided,
proceed,
but let this examination in chief.
Yes.
Is
my lord,
go
that
on.
no reference can be made to that particular evidence which is there.
My learned friend is taking a point in 2014 when the suit started. There were questions 1 to 60 was asked. Then thereafter
If necessary, those will be expunged.
thereafter the issues were reframed. So then when it started de novo, my learned friend had taken a point. There are judgments on both sides. I am okay if it is not, but there has to be an order from my lord because
This will be expunged. Fresh examination in chief
it
will start.
started. It has started fresh because we
Yes.
started from 1. But only thing that we require an order from my lord that 2 exhibits were made, the ABC. So
will be returned to you for fresh production.
so then I'll prove them today again. So then those records can be returned to us. Then your lordship will.
You do one thing. Possibly you will not be able to finish the examination in chief.
No.
I will pass the order, take it back, and next day you produce those documents.
Well, those then your lordship may just for my lord's.
Because the order of division bench is there to proceed with. So
Yes,
you
yes,
proceed with.
I'll proceed. My lord, on 16th of July 2014, those are my learned friend has raised some objections that you can't take
All
it.
right.
I'm
You-
agreeing to it because
I'll pass order. You
otherwise
go
that will become a issue in another appeal.
Yes.
So that is why I'm agreeing.
No,
to
my lord, there is a division bench judgment on this.
Yes,
I am agreeing. We are both are agreeing with
Yes,
you. These documents will be returned by today's order,
Yes.
produced on the next date for exhibit.
So my lord, I'll start again.
And I believe, my lord, the division bench order has been placed because certain observations have been made in the division bench order with regard to preliminary issue when it has to be decided in the earlier order. my
For
lord.
the timing, let the evidence be go.
Very well, my lord.
Yes. So my lord, it will start from question 10. It will continue from question 10. Yes. Well, he's already on oath, so I think. Mr. Roy, what are the names of your siblings whom you have referred to in answer to question 9?
Question number 9 এ লিখেছেন না আপনার ভাই বোনদের কথা কিন্তু নামগুলো
আমাদের ভাই বোনেদের ভেতর মন্দিরা মুখোপাধ্যায় হচ্ছেন আমার বড় দিদি, সব থেকে বড়।
Out of my brother and sister, Mrs. Mondira
মুখার্জি।
Mukherjee, my eldest sister.
মেজো হচ্ছেন পার্বতী গঙ্গোপাধ্যায়।
There is Parvati Gangopadhyay.
গঙ্গোপাধ্যায়।
The next sister, the second sister
Gang-
is Parvati
Parvati
Gangopadhyay.
তারপরে আমার দাদা সুবীর রায়।
After that, my brother, Mr. Subir Roy.
I can't see.
তারপর আমার ছোট দিদি সুস্মিতা রায়।
After that, my younger
সুস্মিতা রায়, SUS। ডেট অফ বার্থ লাগবে?
না।
আচ্ছা।
Can you tell the court if any of your siblings are married?
হ্যাঁ সবাই
If so, about when did they get married?
You have how many sons and daughters?
No,
Hmm?
the
How
brothers
many
and
sons
sisters.
and daughters you have?
Siblings. We're talking about her.
হ্যাঁ আমার বড় দুই দিদির
How many sons and daughters you have?
আমার
Oh, this is a
তিন
court
ছেলে
I have 3 sons.
I have 3 sons.
There are 2 court. But the earlier question, then he should answer that after the court's question.
আগের প্রশ্নের উত্তরটা বলুন। যে আপনার
হ্যাঁ
ইয়ে যে বোনেদের
বোনেদের
যে আপনাদের ভাই বোনেদের সবারই বিয়ে হয়েছে কি?
সবারই বিয়ে হয়েছে, সবাই ম্যারিড।
Everyone is married.
তার ভেতরে শুধু আমার ছোট দিদি সুস্মিতা রায়, তার বিয়ের অল্প কয়েক মাসের পর ডিভোর্স হয়ে যায়।
Out of my brother and sister, my younger sister named
All my brothers and sisters are married except my younger sister, Shushmita Rai,
to get married.
who was divorced. Who is a divorcee?
Divorcee.
After her 3 years.
That's all. Who is a divorcee?
Divorcee.
When did Sushmita Roy get married?
In 1981.
And when were you born?
1957, 9th September.
And since your birth, where have you been residing?
4/1 Rai Bahadur, Ambika Charan Rai Road. Behala, Kolkata 700034.
Who was the original owner of that house where you live in?
আমি এই যে বাড়িতে আমরা রয়েছি এই বাড়ির প্রথমে মালিক ছিলেন রায়বাহাদুর অম্বিকা চরণ রায়।
The house which we are residing, the first owner of this house was Mr.
Was firstly owned by Rai Bahadur
রায়বাহাদুর অম্বিকা চরণ রায়। বর্তমানে এই বাড়িটা অমরেন্দ্র ভবন বলে পরিচিত। আমার দাদুর নামে অমরেন্দ্র ভবন আমার গ্র্যান্ডফাদারের নামে।
in the name of my grandfather,
অমরেন্দ্র ভবন।
Agreed.
What was the occupation of your great grandfather? Ambika বলেন, অম্বিকা চরণ।
উনি জমিদার ছিলেন।
And what was no, that I've asked. Besides this property at Behala, did your family own any other properties in West Bengal?
হ্যাঁ, ওয়েস্ট বেঙ্গলের বিভিন্ন জায়গায় বিভিন্ন ডিস্ট্রিক্টে সম্পত্তি তো ছিলই।
Yes, there was a property in every district in West Bengal.
Every না, many district in West Bengal along with কিছু ছিল ইস্ট বেঙ্গলেও।
With some property are in East Bengal, very in East Bengal also.
There are some properties, full stop after full stop, some properties which were in former East Bengal, now Bangladesh.
Now Bangladesh.
Now, please have a look at your answer to question 2. You have referred to fourth line. You have referred to a property of the trust, inverted commas, is property of the trust. Which now what is the address of the property you have referred to in your said answer?
It's at 24/2 Alipur Road. 2 Alipur Road. এর আগে অ্যাড্রেস ছিল 4 নম্বর আলিপুর পার্ক রোড। আলিয়ার অ্যাড্রেস 4 নম্বর আলিপুর পার্ক রোড।
ইন্টারপ্রেট করছি ভুল তো করবে না, প্রম্পট করবে এটা অ্যাড্রেস
আলিপুর।
And what is the trust, inverted commas, that you have referred to in your answer?
আমার গ্র্যান্ডফাদার অমরেন্দ্রনাথ রায় 8 মার্চ 1951 একটা ট্রাস্ট করেছিলেন।
My grandfather created a trust on 8 March 1951.
সেই ট্রাস্টের ভেতরে অনেক সম্পত্তির ভেতরে এই 24/2 আলিপুর রোডটাও ছিল।
Alipur Road property.
The property located at 24 Alipur Road was one of the aforesaid trust properties.
Amongst others.
Amongst others. Oh, one of the means amongst others.
24/2 ই তো বলেছে।
24/2
Have you had the occasion to see a copy of the trust deed which you speak of?
আমি ট্রাস্ট ডিডের অরিজিনালটা দেখিনি,
I have not seen the original of the trust deed.
আমি সার্টিফাইড কপিটা দেখেছি,
I've seen the certified copy of the
যেটা আমি নিজে তুলেছিলাম
which I have procured from
রেজিস্ট্রি অফিস।
registry.
Well, since those documents are already exhibited, next day I'll do the documents. I'll just go. Then
You asked questions today?
Yes. Do you know who the trustee of that trust was?
এই ট্রাস্টের ট্রাস্টি ছিলেন আমার বাবা, লেট শৈলেন্দ্রনাথ রায়।
Trustee of the trust was my father, late
শৈলেন্দ্রনাথ রায়।
And do you know who were the beneficiaries, ultimate beneficiaries of this trust?
হ্যাঁ, ক্লজ 7 of the trust deed মেনশন করা আছে
mentioned in the clause 7 of the trust deed
that settler বলছেন after demise of my son, that is শৈলেন্দ্রনাথ রায়,
stating that after demise, the settler is stating that after the demise of
my son, only son শৈলেন্দ্রনাথ রায়, the entire residue of the trust property shall vest
residue of the trust property
on Shubir Kumar Rai, my son's son, that is grandson, and any other son or sons that may be born to my son, that is Shailendranath Rai.
born to my son is
Shailendranath Rai. Trustee. ROI.
And do you know when the property was meant to, the properties were meant to vest in the beneficiaries of the trust? When?
কোনটা প্রশ্নটা হ্যাঁ, আমার বাবা মারা গিয়েছিলেন 23rd November.
When was it to?
23rd November 1990.
প্রশ্নটা বুঝে নিন, প্রশ্নটা হচ্ছে প্রপার্টিটা ভেস্ট কখন হওয়ার কথা?
যে আফটার ডিমাইস অফ মাই সান, দ্যাট ইজ আমার বাবার মৃত্যুর দিন, দ্যাট ইজ 23rd November 1990.
property was supposed to vest on
on 23rd November 1990, যেদিন আমার বাবা মারা যান।
when the day of my father died.
Now, Mr. Roy, when no, did during the subsistence of the trust, who used to look after the trust property besides your father, Shoilendranath Rai?
এই ট্রাস্ট সম্পত্তি আমার বাবা ট্রাস্টি
The trustee of this property was my father,
শৈলেন্দ্রনাথ রায় as trustee with the help of manager of the estate উমাপদ বন্দ্যোপাধ্যায়, now deceased, along with 3 other estate officers এই সম্পত্তিগুলো দেখাশোনা করতেন।
looking after the property.
He was one man show. এই সম্পত্তির ব্যাপারে পরিচালনার ব্যাপারে আমার বাবাই কর্তা ছিলেন এবং ওয়ান ম্যান শো ছিলেন।
My father was the one man show of this property.
You have spoken of a property at 24/2 Alipur Road. Who was in occupation of this property when you were born?
হ্যাঁ, এই প্রপার্টিটা আমার জন্মের আগে থেকেই এ এম মায়ার অ্যান্ড কোম্পানি, এ ফুলস্টপ এম মায়ার অ্যান্ড কোম্পানি, MAYER মায়ার অ্যান্ড কোম্পানি টেনেন্ট ছিল in respect of both upper and lower flats.
There was a tenant that is tenant namely A.A. Meyer and Company before
আমার জন্মের আগে থাকতেই
before my birth.
থেকেই এটা
They were the tenant.
টেনেন্ট ছিল।
They were the tenant of the property.
Is this company still a tenant in respect of that property at
No.
at 24/2 Alipur Road?
না, আমরা এভিকশন ডিগ্রি পাই
They have got eviction decree
against A.A. Meyer and Company.
Who do you mean by inverted commas we, Amra?
আমরা মানে হচ্ছে আমার বাবা, আমাদের পরিবার,
my father, my family.
When was this eviction decree passed? Do you know?
হ্যাঁ আমি দেখেছি
I've seen
কাগজে
the paper.
31শে জানুয়ারি 1970-তে ডিগ্রি পাওয়া গিয়েছিল A.M. Meyer and Company এগেইনস্টে।
We have got the decree against the A.A. Meyer and Company on 31st January 1970.
Who was the decree holder?
শৈলেন্দ্রনাথ রায় ট্রাস্টি was degree holder.
Do you know whether this decree was implemented and executed?
হ্যাঁ, এই ডিগ্রি এক্সিকিউশনে দেওয়া হয়েছিল।
Was given for execution.
নাম্বারটা এক্সিকিউশন কেস নাম্বার 8 of 70,
Being
number 8 of 1970. এবং 8-এর ডিগ্রি এক্সিকিউশন করতে গিয়েছিলেন আমার বাবা।
my father is going to execute the
8 May 1976-এ
1976.
with belief নলিনাক্ষ চট্টোপাধ্যায় অ্যাডভোকেট of the trust estate এবং অন্যান্য যারা ট্রাস্টের কর্মচারী ছিলেন তাদের সঙ্গে নিয়ে
with the other employee of the trust.
সেখানে আমার দাদাও উপস্থিত ছিলেন, দাদা সুবীর রায়।
My lord, only one thing, my lord, the question is something, the answer is much more than what has been asked. Only thing is, my only request is, it should go as witness volunteers after the answer. My lord,
Yes.
because in all answers, this is happening.
যেটুকু প্রশ্ন করা হবে সেটুকু উত্তর দেবেন, বাকি যদি বলার থাকে বলে দেবেন, ভলান্টিয়ার হিসেবে যাবেন।
He's just answered the question. What is the question? পড়ে দিন।
If we want to go into details, those will come as volunteering to the court.
I can't see, because generally.
Executed.
Why didn't you do this? How will I change petition and everything?
My lord, let my learned friend come this side.
Because otherwise it becomes
Over
difficult.
my shoulder, I'm getting nervous.
Sir, I can't see, my lord, because my view is getting blocked.
You can see here.
Well, then I can appear virtually only according to my learned friend, or I should leave the court and watch it from somewhere else.
Maybe.
What my learned
You
friend
can
is
watch
saying.
it from here.
Anyway, proceed. If you want to
If you want
need
to
any
come
problem,
this side,
come here.
this side.
Yeah.
The petitioner, though is written here, the petitioner is this side.
Well,
That is no matter. You come here. If you are comfortable here, come here, please.
But it just helps, my lord. Generally.
তুমি বসো, আমরা এখানে দাঁড়িয়ে আছি। একটু প্রশ্নটা পড়ে দিন। তোমরা এই দিকটা চলে এলো। প্রশ্নটা একবার উপরে দিন, কি ভলেন্টিয়ার করলো, কি করলো।
Yes.
76. 76.
And my father went to the duty on 8th May 1976 with him. Was Nolinakshu Chattopadhyay of the
With beliefের নাম নলিনাক্ষ চট্টোপাধ্যায় না।
of the trust estate.
No, bailiff and.
Bailiff and ওটা volunteer করে নেবে।
And of the trust estate along with other employees of the trust, and there my little brother Subi Roy was also there.
What my question was the decree executed?
হ্যাঁ।
Yes.
And who took possession of the property on the day your father went to execute the decree?
আমার বাবা as trustee position নিয়েছিলেন।
Father taken possession of the property of the trustee of the trust.
At that time, after he took possession, who was in occupation of the premises?
বাবা যখন ডিগ্রি এক্সিকিউট করতে গিয়েছিলেন,
When my father went to execute the decree,
তখন
at that time
কেলভিন জুট মিলের ম্যানেজারের স্ত্রী উপস্থিত ছিলেন।
that point of time, the wife of manager of Kelvin Jukmir also.
Kelvin spelling?
KELVIN.
What was her name?
মিসেস রায় বলে শুনেছি আমি নামটা।
I've heard as Mrs. Roy, but I do not recollect the exact name right now.
Did she vacate the premises on that day when your father went to execute the decree?
করেছিলেন?
হ্যাঁ, উনি ভেকেট করেছিলেন।
Yes, vacate the property.
উনার হাজবেন্ড এসেছিলেন।
Her husband was came.
Husband came.
Husband came.
উনার হাজবেন্ড NB রায়, N full stop B, NB রায়,
NP Roy.
along with উনাদের ল অফিসার,
Along with their law officer. Namely
RS জৈন,
RS Jain.
হ্যাঁ RS জৈন সেখানে উপস্থিত হয়ে পজিশন দিয়েছিল।
Was also present and was also present there and take the position.
This will be your point of argument.
No, my lord, if evidence is being laid, which is not even in the pleadings,
That will be not accepted. At the time of argument, you will raise this point.
my lord, only kindly note. that
Otherwise, why give evidence if I have to read out
All right,
my
objection.
plain?
Kindly read.
Because at the time of asking question, he will not go through every line of the plaint and ask the question.
প্রশ্নের আনসারটা পড়ে না, লাস্ট 3টে লাইন পড়ে দিন, তাহলে মনে থাকবে।
Her husband Roy, along with other law officers, namely RS Jain, was also present and there and helped to take upon.
NB, B for Bombay.
At that time, what was your age in 1976?
আমি সবে কলেজে ঢুকেছি।
That time I was just
What was your age?
এইজটা আমি 57 এ জয় হলে 76, 18 প্লাস
I was about 20 years.
about 20 years.
18 plus is it? Whatever. And how did you come to learn about this execution proceedings at that time when you were only in college?
8th May evening এ one দেবেন্দ্র বাজরিয়া along with his law officer রাজেশ কৈতান আমাদের বাড়িতে এসেছিলেন।
law officer namely
দেবেন্দ্র বাজরিয়া along with his law officer না lawyer রাজেশ কৈতান ইভিনিং এ আমাদের বাড়িতে এসেছিলেন আমার বাবার কাছে to express their gratitude. সেই সময়
that point of time
আমি যেখানে পড়তাম আমার পড়ার ঘরেরই অনেক বড় ঘর হল, সেই হলেরই একটা পোর্শনে আমার বাবা বসে কথা বলছিলেন।
at that point of time I was
Student.
I was a student and I used to study at this is a very big
hall
and
সেখানে আমার বাবা ওনাদের সঙ্গে বসে দেখা করলেন এবং
There my father met him.
এবং সেই দিনে সারাদিনে কি হয়েছে সেই সমস্ত ব্যাপারগুলো নিয়ে আমার বাবা বিভিন্ন প্রশ্ন করছিলেন, হ্যাঁ ডিসকাস করছিলেন।
On that day, my father discussed the entire matter of the day with them,
হ্যাঁ, যেটা আমি শুনতে পাই
which I have heard.
এবং আমি উঠে গিয়ে টেবিলের পাশে বাবার পাশে দাঁড়িয়ে শুনেছি।
And I have heard that just beside the table where they were
Standing beside my father.
beside my father.
Why was Mr. Devendra Bajoria expressing inverted commas a gratitude?
বাবা পজিশন নেয়ার পরে
So taking possession by my father,
তখন দুপুরের পরে প্রচন্ড বৃষ্টি ঝড় উঠেছিল।
on that evening,
ইভিনিং না দুপুরে, মানে আফটারনুনে
on that afternoon, there was a
Thunderstorm.
হ্যাঁ
thunderstorm.
Thunderstorm.
সেই সময় ওনারা আমার বাবাকে রিকোয়েস্ট করেন যে এত মালপত্র জিনিসপত্র নিয়ে আমরা আমরা চলে যাচ্ছি, কিন্তু আমরা এই এত মালপত্র আমাদের যদি একটু জায়গা দেন একটা ঘরে, তাহলে আমরা সেখানে সমস্ত মালপত্র যেটা নিয়ে যেতে পারবো না সেটা রেখে যাচ্ছি।
On that point of time, they requested my father that we are leaving, but if you give a room to we are leaving, but if you give a room to
At that time, they requested my father for accommodation of goods which could not be transported or taken away because of inclement weather.
সেই মতো ওই ঘরেতে ওনাদের মালপত্র রেখে 8 তারিখ থেকে 12 তারিখ পর্যন্ত বাবা সময় দিয়েছিলেন ওনাদের মালপত্র রেখে দেওয়ার জন্য।
my father has
সেটা
given permission-
লিখিত আছে।
My father has given permission to keep their goods from 8
মে থেকে
8 May to 12 May,
12 মে, যে 12 মে ওনারা
and
ভেতর ছেড়ে দেবেন আর কি।
the agreement is in written.
এগ্রিমেন্ট জাস্ট একটা এনবি রায়ের লিখে দিয়েছিলেন, সেই হাতের লেখা কাগজটাও আছে।
এটা কি বলবো?
হ্যাঁ, মানে
Has
একটা
been written down.
রিটন একটা নোট দিয়েছিলেন।
This has been written in a note,
নোট আর বেলিফের রিপোর্টেও আছে।
and it is also in the bailiff report.
Do you
1976
did NB Rai leave the premises on the day mentioned by you?
না,
Going to a
ওনারা-
leading question. Ask the question in a roundabout way.
No, he has said that he was to leave on that date. So my next question is, did he leave?
না,
The next date.
8 থেকে 12 তারিখের পর ওরা ছাড়েননি, এবং ওই ইভিনিং এ ওনারা এসেছিলেন আমার বাবাকে রিকোয়েস্ট করতে যে টাইমটা একটু বাড়িয়ে দিন। বাবা সেটা রিফিউজ করেন।
So they have not
On 12th evening, Mr. N.B. Rai came to my father praying for extension of time.
এই এনবি রায় আসেননি, দেবেন্দ্র বাজোরিয়া এসেছিলেন এনবি রায়ের হয়ে, যে আমার ওনাদের কর্মচারী থাকে যে একটু টাইমটা বাড়িয়ে দিলে ভালো হয়, তো সেটা বাবা রিফিউজ করেন।
Devendra Bajoria came on behalf of Mr. N.B. Roy
হ্যাঁ, এনবি রায়ের জিনিসপত্রগুলো আরেকটু কিছুদিন রাখতে দিলে ভালো হয়।
asked for extension
এক্সটেনশন অফ টাইম
for extension of time.
which was refused by my father.
Refused by my father.
What happened thereafter?
13 তারিখে আমাদের অর্থাৎ ট্রাস্টের কেয়ারটেকার যিনি ছিলেন তাকে এবং আমাদের দরওয়ান যারা ছিল তাদের জোর করে মেরে বার করে দেওয়া হয়।
On 13th May, তাই তো?
হ্যাঁ
13 May 1976, the caretaker and the
Darwans
watchmen were ousted from the
from the building
from the
from the building বাবা সেই দিনে মানে 13 তারিখে বাবা ছিলেন না কলকাতায়, চন্দননগরে গিয়েছিলেন একটু কাজে।
was not in Calcutta on 13th May. He went to the Chandanagar.
হ্যাঁ 14 তারিখে ফিরে এসে বাবা সেটা পুলিশে ডায়েরি করে জানান।
On 14 May, my father returned and filed a GD before the police station.
আর একটা 144 করেছিলেন।
Also filed a 144.
হ্যাঁ CRPC
Also filed an application under section 144.
Then did your father as trustee ever get back possession after that day on 13th May
না আর পজিশন ফিরে পাননি,
1976?
No, not case.
পজিশন ফিরে পাননি।
After your after your father died in 1990, what steps did you or your brother take? What steps did you take to take in respect of these properties?
বাবার জীবিত অবস্থাতেই বাবা মারা যাবার পরেতে আমার নলেজে আসে, আমার নলেজে ডাইরেক্টলি লিটিগেশন তো আমি দেখতাম না,
I used to not look after the litigation.
সেই জন্যে 91 ডিসেম্বর পর্যন্ত ওই বাজরিয়ারা বা এনবিরা মায়ার অ্যান্ড কোম্পানির তরফ থেকে যেটা একটা সেকশন 47 এর দরখাস্ত করা হয়েছিল,
41 application
47
under section
7
47, which was filed on behalf of the
একটা মিসকেস ফাইল করা হয়েছিল এই মায়ার অ্যান্ড কোম্পানি, সেই প্রসিডিংসটা চলছিল।
This proceeding was
চলছিল, আমার বাবা সেটা জবাব দিয়ে সেটাকে কন্টেস্ট করছিলেন।
My father was contesting the application.
বাবা সেটা
Kindly see what the question was and what the answer is.
Give the answer to the question.
Answer is that what steps were taken as what was asked.
Yes. What step did you take?
আমার নিয়ে কোনো অকেশন ছিল না, মাই লর্ড, আমার I was in dark.
So your answer is, since you did not look after the properties, you had no occasion to know. This will be the answer.
After the property, so I have no
Please interrupt it. Let him finish the answer and let it go
Now-
down
now
as
you continue.
volunteers. I know what my learned friend is saying. I can't help that.
Next.
No, he hasn't finished the answer. The প্রশ্নটা শুনুন আপনি।
After your father died in 95, what steps did you take in respect of his property?
আমি কোনো স্টেপ নিইনি
I have not
তখন,
taken any step at
আমি
that point of time.
টিল 91 পর্যন্ত আমি কোনো স্টেপ নিইনি। ডিসেম্বর 91 ডিসেম্বর পর্যন্ত আই ওয়াজ কমপ্লিটলি ইন ডার্ক। আমি জানতাম ওই মামলাটা চলছে।
I know that the case was pending.
What happened after December 1991?
ডিসেম্বর 1991 আমার বাবার শ্রাদ্ধ মানে মারা যাওয়ার 1 বছর পরে,
After the demise of my
1 year after demise of my
হ্যাঁ
father.
ডিমাইস অফ মাই ফাদার,
Document পড়ে থাকো।
সপিণ্ডকরণের পর I had the occasion to open a joint locker, যেটা আমার বাবার সঙ্গে আমার নামে ছিল,
which was in the name of my father and me joint.
আমার নামে ছিল এই হাইকোর্টের পাশেই স্টেট ব্যাংক অফ ইন্ডিয়ায়।
Just beside the High Court, State Bank of India. কিছু বলবেন?
ফাদার আর কিছু করতে পারি এখানে? আমি ওই লকার নাম্বার 4 যেটা আমার এবং আমার বাবার ছিল,
Local number 4 being which was in the name of my and my father.
আমি সেখানে আমার মাকে নিয়ে গিয়েছিলাম নাম ইন্ট্রোডাকশনের জন্য, যে আমার সঙ্গে যাতে নামটা যৌথ থাকে।
Where I have taken my mother to include my mother's name in this locker.
লকার।
Mr. Ghosh, this much today. I have other witnesses. This much today.
Let him complete this answer.
Yes, let it be complete.
ওই লকারটা খুলে যেখানে জুয়েলারি রাখা ছিল মেনলি, সেই লকারটা খুলে আমি একটা টাইপড কপি অফ 1971 এর ডিডের একটা টাইপড কপি পাই, ওপরে ডুপ্লিকেট লেখা, তাতে কোথাও কোনো সই ছিল না। ঠিক ঠিক ঠিক।
When I have opened the locker, I have got a type. I've got a duplicate deed, which is type of the year 1971.
1971
1971.
Which was unsigned. কোনো সই নেই।
এটাই কোনো যেটা কোনো আনসাইন্ড সই ছিল।
Let us stop there.
এবারে অর্ডারটা লেখো। Which all
July 14th, 2014. Yes. July 16th, 2014.
As agreed upon by the learned counsels, evidence of the PW1 taken on July
16, 2014.
July 16, 2014
Brackets in
stands
question 1 to 60.
testimony of PW1 dated July 16, 2014 stands expunged from the record.
Question 1 to 60, 60.
Question bracket लिखे था 1 to 60. 60 stand expunged. Full stop. Documents exhibited be unmarked and returned to the parties for fresh production.
To the plaintiff.
But to the plaintiff for production afresh.
Great. And on the next day, we will take it.
PW1 is examined in chief in part. Further examination is deferred to 18 June.
This month.
But the only thing is, well, kindly just record where your lordship has recorded the objection, because this is going to go on for a while. Objection is on the ground. Well, that
Going beyond pleading.
গৌতম রায়।
does not form part of the. This is there.
Whenever any question will be asked to you, try to answer it pointedly. If you want to digress, if you want to say more, then say, this is my view.
18.
Adaptation can happen, but volunteering can't happen something absolutely on something unconnected.
If he wants to volunteer, I cannot stop him. But so far as the evidentiary value is concerned, you ask that.
Your lordship has
Before he speaks out, I am not supposed to.
After he has completed the answer,
It may be relevant. Maybe some of, because these are nothing unrelevant. If not in pleading, it will be not considered.
Yes.
Next.
that objection.
Yes, that objection is marked.
Mr. Rai, 18 June. ঠিক আছে?
18 জুন। একটু দিনটা দেখে বারটা একটু দেখে
বার সোমবার তো না? না মঙ্গলবার।
Tuesday.
এটা একটু বুধবার হলে আমার সুবিধা।
19 June. দেখো তো।
19th আমি দেখলাম এই ফিল্ডে yes.
19 June.
19th 2 o'clock I'll be in difficulty when I have a suit. 20th
20th June.
20th.
Hopefully your appeal will be over by that time.
Then 20th. But on the day the Amphan happened, one portion of our house, the roof blew off, tin roof, and it went to the neighbor's house. Then in the morning after the storm, we were repairing it, and I asked for the thing back. My whole entire roof of one room had gone to that, and the roof. Then he's brought it down. It was not coming. Then I asked him what happened. He's saying today is Thursday. Nothing can go out of my house. I have not shouted so much for a long time. I got saying Brihospati pare হবে না। Not bad luck. তুমি থাকো এবার।
Item 28, mobilize.
Just come.
Item number 28.
Hey, Yudhika, you want to come this also?
Please chief for.
Mr. Banerjee is the other side. Bandhopadhyay, sorry.
Yeah, after yesterday, even I found an interesting fact. Then I want to also not confirm today. Your Lordship is born on 25th December.
PRAVIN.
I was also born on
PRAVIN. V for victory. Praveen K. Popat. POPAT.
Yes.
13 Jan.
No, PD. Sir, I have only 4 more questions. It was almost over.
Any document to show?
Yes, so I did not have certified copies. Certified copies of 2 orders.
Produce this. If it is admissible, then it will go.
If it's certified copy of an order, I have no ground to object of an order. If the certified copy of an order, I have.
I'm showing you original certified copies of PD 18 and 19
What are these documents?
of the additional.
What are these documents?
These are the documents, are the certified copies of orders passed in writ petition number 471 of 2004 by the High Court of Calcutta.
Same order or number of other different orders?
There are 2 orders on different dates.
Dated?
On different dates. One order is dated 27th of July 2004. The other order is dated the 21st day of February 2005.
Same writ petition.
Same writ petition.
In the same writ petition. Collectively marked.
Correct. It will be yes, 17, 18.
Question that request for the.
He is the plaintiff.
Who?
He is.
Yes.
So it will be by letter.
By letter, my lord, I said I am showing original of PD. PD 1718. That also I am showing you.
Collectively by.
I'm showing you an original letter dated 4th March 2005, which is PD 19 of the additional judge's brief of documents dated 30th April 2024. Please tell my lord what the document
This document is a letter dated the 4th day of March 2005, written by
Sri Siddheswar Chandra, advocate. Siddheswar Chandra, advocate, addressed to the plaintiff society.
Do you know his signature?
Yes, I know the signature of the advocate Siddheswar Chandra.
You encircle it.
Yes.
Encircle the signature with blue pencil. That will be marked. The earlier was K, L.
Document A and
L by 1.
Not subject to objection.
Objection. Is it original?
Say yes.
Yes.
This is the original document. কতটা লিখে রাখবে?
I am showing you a document which appears as PD7 in the judge's brief of document. Additional judge's brief of document at page 55. Kindly tell my lord what the document is.
This document has been downloaded.
What is the document?
This document is the SSC Municipal Assessment Book details of the Calcutta Municipal Corporation.
Assessment book
Details of the Calcutta Municipal Corporation regarding the premises number 20, regarding the premises number 29 Pollock Street belonging to the plaintiff society.
Let me see it.
Obtain this document. How did you obtain this document?
This document was downloaded from the website of the municipal corporation, being the KMC portal, by me personally. Pollock, P-O-L-L-O-C-K. P-O-L-L-O-C-K.
What device did you use while downloading this document?
This was downloaded from the office computer by me.
X for identification.
Those are my
65B, where is 65B?
That would have been my objection.
No, even if you do
Would have
not object that, this is inadmissible document.
Yes, would have been. I need not take it. My lord is all.
Come on the next date. Any other question you have to ask? Then come on the next date. Once you start cross-examining, you will get lost the opportunity. Or if you like to withdraw this document, then that's different.
No, my lord, I want to go with the document because I did not have a 65B, my lord. I was asking those relevant questions, my lord, so that it can be. So what make, my lord, a few more
PW, he is
questions then-
PW1.
Yes.
PW1 is examined in chief in part. On prayer of the learned counsel for the plaintiff, further examination in chief is deferred to. চাকি আছে? 12 June.
Milord, 12 June. Can it be any other day but the 12 June, Milord?
14 June?
Any, yes, Milord.
14 দেখো কটা আছে? দুটো আছে তো? 14 June.
Extremely obliged.